Well, everybody, we are getting close to the end of the road here. In the case of State versus Richard Allen, we've just concluded day 14, and the word is that the state is going to be resting tomorrow. And so then we will move on to the defense case. Don't know how much we're going to see. When the original trial dates were scheduled, it was in contemplation of the defense putting on a pretty lengthy third-party culprit defense. And as I'm sure most of you know here, that third-party culprit defense was excluded by Judge Gull before trial. So they're going to have to try again just for purposes of preserving their appellate record so that they can go to the Court of Appeals if Richard Allen is convicted and argue that that decision violated his constitutional right to present a defense. But I'm not expecting Judge Gull is going to change her mind on that. Just not getting a real read, a real flexibility kind of read from her that would lead me to think she would be open to the idea that maybe the trial process has opened that kind of door or anything like that. So without that evidence going forward, don't know really how long it's going to take the defense to put on whatever they have up their sleeve. And we know that they have some stuff up their sleeve because we got a big old hint about some of it today. So let's go ahead and talk about what happened. 10,000 foot view, the quick takeaway for you folks. Primary witness for today was Dr. Monica Walla. She was the clinical psychologist at Westville Correctional Facility. She is the one who provided therapy services to Richard Allen. And as a result, she was in contact with him, had a number of conversations with him, and she has provided what is so far the most detailed accounting of the crime that Richard Allen has made so far. Specifically, the detail, we heard in opening statements that he was going to confess to details that only the killer would know. And so today it became a bit clear what that detail was, because part of the confession that she relates is that Richard Allen claims that he was in the course of committing this crime, attempting to kidnap and have his way with the girls, when a van came by and it scared him. So at that point, he abandoned his efforts and simply killed the girls and made his way back home, where he then lived quietly and undisturbed for the next 5 years. So this white van, is a detail that has not been discussed before at trial. We heard from the owner of the van at the end of the day, and it sounds like the defense has got something up its sleeve to suggest that the owner of this van may not be particularly credible in his effort to place it on the driveway under the Monon High Bridge in the approximate time frame of when the murders, according to the state, would have taken place, about 2:30 on February the 13th. With respect to Dr. Walla, her credibility really got hammered hard today by the defense, because it turns out she's quite a true crime junkie herself, and not only investigated this case, continued to follow it, read it on social media, was putting comments out on the internet on a variety of platforms discussing the case, visited the Monon High Bridge. Not only was she doing all of these things while she was providing treatment to Richard Allen, but she was apparently even talking to him about it. And so this is particularly damaging to the extent that it gives the defense an opening, a possibility to argue. She fed him the information. So that will remain to be seen, but it wasn't a super long day today. So this time, actually, I think it really won't be that long of a stream. I did not get through an entire legal pad I'm about 10 pages shy of my legal pad, so a little bit more in the normal realm than we've had the last few hearings. So with that, let's go ahead and start breaking it down in the details. First, our Brad Rosie style watch. Today, he was in a black suit, a light blue shirt, like much lighter than some of the other blue shirts he's worn. He's worn this kind of, I call it like a robin's egg blue or like a sky blue kind of shirt. It's kind of got like it's not a real bright shirt. It's certainly not a dark shirt. It's not a dark blue, but it's saturated. It's a vivid color that you can see. This one was extremely subtle. It was very, very light. It just picked up a little bit of a hint of that sky kind of color. His tie was a pink tie, and it appeared to have, again, a sort of metallic pattern to it, a very subtle pattern, perhaps dots, perhaps very, very thin stripes, something like that really was just enough to give it a little bit of a sheen from a distance. So yet another one of these very eye-catching ties, and a unique color combination that he comes up with that just seems to work so well for him. We had a visitor in the courtroom today, Nancy Grace. Nancy Grace was there with us in the courtroom. She was there until about 10 o'clock in the morning. Basically, she attended the part of Dr. Walla's testimony where Dr. Walla testified to the specific substance of the confessions that she claims that Richard Allen made to her. And pretty much right upon hearing those, before we even reached a break in the action, Ms. Grace was out of the courtroom. She had heard enough and was off to do her reporting, apparently over on the far sidewalk across the street from the courthouse. So the rest of us, who stuck around, will have a little bit more detail to provide to you as far as firsthand accounts of what took place in the courtroom today. We again had the situation where the prosecutors, they're like discouraging the witnesses from using the microphone. So once again, there were moments where it became difficult to hear. Most of the time, Dr. Walla was pretty audible, wasn't too much of a problem. But there were some points where she was rattling off a lot of information very quickly. A lot of times where she was looking down at her notes while she was reading. So her mouth is even further from the microphone and her voice is being projected down into her lap. And those things both made it a little bit difficult to ascertain some of the fine points of what she was saying. But several of us did get together at several of the breaks and kind of compared notes, figured out what this person caught that this other person missed. And for the most part, I think we were able to reconstruct those missing parts where it was needed. So I certainly got help from several people at a few points where I had missed the exact answer that was given. So Stacy Diener was handling the direct examination today, and it was clinical psychologist, Dr. Monica Walla. She is a PhD psychologist, and she was the lead psychologist at Westville Correctional Facility from 2022 to 2023. She works for a contractor for the state, a company called Centurion. We were just the other day talking about kind of the prison industrial complex, right? And I sort of maybe overly quickly jumped to the point of how Indiana prisons are themselves. They're operated by the state, operated by an agency, and it's similar in my jurisdiction in Washington. I talked about how there are kind of some growing privately operated prison facilities, but by and large, our prisons are publicly funded, publicly operated. But it's true. This was a big oversight that I didn't talk about and I didn't really account for when I was having that discussion, which is the role of the private contractors, the service providers, the ones who provide the medical, provide the food, provide the telephone, provide the commissary. A lot of what is going on inside the prison that is beyond just maintaining the walls and staffing the institution, the guards, the janitors, the administrators, all of those types of folks. So it would be a very fair critique if anybody made it. I didn't see it, but if you had, it was certainly a very fair critique that just because a prison is publicly operated, it doesn't mean there isn't still a vast amount of private financial interest that's implicated in the operation of those institutions. So her employment with Centurion today did remind me of that. In her case, she didn't necessarily, because she was the supervisor, she didn't necessarily maintain an entire caseload. She would just take on more serious cases that needed special attention. And so that brought her to Richard Allen. She provided services to him in the area of mental health. Initially, it was just her and the psychiatrist who administers medications that were providing this treatment, but later they also brought in some master's level providers to help them with some of those therapeutic things that they were doing. She said it was just assumed that she would take on the role of being his primary provider because of the high profile nature of the case, and because it required more time and more services than other inmates did. There was nobody else. He was the only one that she would see every day or for an extended period of time at different points when she was servicing him over these 13 months. Sometimes it was every day. So he was very exceptional in that regard. She maintained the records that she kept about him in a digital electronic record keeping system. And that's similar, same thing that they use for all inmates. It's a secured system. And so what she would do, she described, is she would have a meeting. Sometimes it would be in a cell. Sometimes it would be in a special room that she called the cubicle and that Mr. Rosie called the cage, where they would talk through a screen, talk through a grate, basically. And she would take notes on a piece of paper. And then when she was back in her office, she would go ahead and input those into her desk, into her computer. She did say, though, that with other individuals, she would often have her computer with her. When she was taking her notes, she would just take them directly into the computer. And there was really no explanation given for why Mr. Allen was different in this regard. She reported that she would meet with Richard Allen both in his cell and then in this A-pod cubicle. So she acknowledged this was a room. It had a partition in it. He was on one side. She was on another. We heard a little bit about this yesterday. She testified that he would be unshackled once he was brought into the cubicle. He would be shackled fully to be brought there and then unshackled once inside. Ideally, she would enter notes the same day. Sometimes she would also do an addendum report, and there are various reasons for this. She indicated that one example might be if they had a second meeting in the same day, or also when she was discussing diagnostic criteria for the diagnoses that she gave, she kept those separate from her primary report. So her reports were admitted into evidence. Only one of them was published to the jury in the sense of giving them the copies, but she did work through both of them just through the testimony, having the information that they contained introduced into the record, into the testimony. So we heard the vast majority of, I think, what is substantive, or at least what the state wants to be substantive in this case. And of course, Mr. Rosie had an opportunity as well to cross-examine on the other parts that he felt were pertinent. But we don't get that context that the jury is going to have. The jury is going to basically see all the notes, it appears, from day one till the day he was discharged, every single day. It should all be in there. We, of course, just got the highlights, the selected portions that one party or the other really wanted to call out for our attention. So as far as getting an overall view of Richard Allen's time in the Westville Correctional Facility, the jury is going to have a much fuller picture than we sitting in the audience received. The first set of documents that we looked at started quite a bit after she began first treating Mr. Allen. She encountered him first when he was transferred into Westville in November of 2022. But the documentation the state wanted to bring our attention to started on April 5th. So she spent some time first just going over, here's kind of the structure of the document, because we're going to be looking at a lot of these different things. And so they have various categories contained in them, ways to identify who we're talking about. So we'll know that it's Richard Allen. Talk about the type of the visit, which in this particular case was suicide monitoring. And for many of these is going to be suicide monitoring. It would describe his observation status, which was daily in this case. There was a section that would outline why the person is on suicide watch. So it would be talking about when the decision was made to place him on suicide watch, what the circumstances were that surrounded that decision. She then talked about the distinction between close observation and, boy, what was the other word now? I didn't write it down at this point. I'll have to remember it when I get to it. Totally drawing a blank on what the alternative to close observation was. Oh, constant. Pretty sure it was constant. So constant observation is literally what it sounds like. You're there 24 hours watching him, eyes on the entire time. The close observation is this one that we heard about yesterday from the guards, where they basically supervise at 15-minute intervals. So basically, at a minimum, every 15 minutes, somebody needs to take a look inside the cell, make a little note of what they see and what they hear. But otherwise, for the rest of the 15 minutes, they can be out going about their business, doing other things. They don't have to be seated right there by the cell, paying attention to it. And she indicated that this was what the suicide companions were for, that they would make these logs that we saw. And she then relied on those logs to get information about Mr. Allen. This was fairly important from a garbage in, garbage out kind of standpoint, because, of course, having heard those logs yesterday, we heard a lot of unqualified opinions about his genuineness, the symptoms, and whether these were indicators that he was feigning mental illness or whether he was genuinely disturbed. And this is a very important distinction, because although they didn't use the word malingering today in court, malingering is a formal diagnosis that can be made. And it often comes up in forensic settings. It's defined as when somebody is feigning mental illness for purposes of secondary gain. And so it just means you're faking it to try to get something out of it. You think it's going to be to your advantage in some way if people believe that you're mentally ill. They have instruments like tests, specific objective tests that can be used to evaluate malingering. And it's also sort of coded into a lot of the different types of testing that psychologists will give to people. And it does that to help validate the results that they get. If the score for malingering tends to reach a certain cutoff point, then it will tend to invalidate the test, because that person is not really mentally ill. And so that can be an indicator, like a kind of red flag to that practitioner, that this is not a real problem here. There's something else going on that is causing the person to behave in this manner. Sometimes I see malingering a lot. I see malingering a lot in criminal practice. It's really not particularly uncommon, because people know. If they get crazy, they can plead insanity. They can try to get a competency stay, and then they get a trip to the hospital, which is much less restrictive than it is over in the jail setting. So especially sophisticated criminals. I'm not saying smart criminals. I'm just saying sophisticated criminals, ones who have been around the block a few times. This is a trick that some of them can pick up. And sometimes it's pretty obvious, at least to the professionals, when somebody is feigning or not, because the symptoms that they're displaying, they don't correspond with how people who genuinely have those disorders would behave. And so it's very common that somebody will be pretending to have hallucinations, to be seeing things, to be hearing things, and they'll describe it, but what they describe isn't consistent with the way that a person who is genuinely psychotic would describe those types of symptoms. So when I see it, when I see malingering in a forensic context, it's usually a situation. I'd say most often it's been a situation where somebody has been found, at least on a preliminary basis, incompetent to stand trial. And so because of that, the process can't go forward. It has to be stayed while they go through treatment, and there's an effort to restore them to functionality. And so the standard is just basically, is this person have the capacity to assist themselves in their own proceeding? Do they understand what's going on? Do they know who the participants are? Do they have a general sense of what's in their best interests? Things like that. And so people will often pass that initial screen because it's very deferential to, one, the attorney's perspective. If this person is making it difficult for me to be able to cooperate with them, to assist them, to advise them, to get decisions from them, and it seems to be because, they understand, I'm not a mental health professional. I'm not in a position to say if it's genuine or not. I just know I have a problem doing my job. So that perspective gets a lot of deference, and the initial competency screening tends to be a lot less rigorous than what goes on later if there is a restoration process that's ordered. So it will often come up in that kind of context. There's been this sort of preliminary suspicion where the psychologist may have come out to do an evaluation to decide if this person is competent or not, and they may have suspicions at that point, but they'll often let it go forward, get the person into the hospital setting, and then do some of this more structured, objective testing. And then I will get a report that has, very bad news and often some sort of stern, finger wagging type of language about, what a terrible manipulative person my client is, trying to feign mental illness. So that's why the logs are important, because she's relying on lay people to kind of get her to that initial point of suspicion, and that may not be the most reliable source of information that she could have hoped for. So Richard Allen, in this particular timeline, he was placed on suicide watch on April the 4th. So before this, she would not see him daily. When he first came into the institution, he was already on suicide watch. He was removed. He stayed on it for the first month that he was there, and then he was removed from it, released from it in December of 2022, and then he was off suicide watch until April 2023. After he came back on April 4th, we didn't hear an end date. It wasn't clear to me if he remained on suicide watch for the rest of the time that he was in Westville. And that is, I think, a little bit important just because of what we learn about the conditions and the restrictions and really what that means, how that's different from him still being in this cell, because that's clearly the only place they're going to keep him in the entire time he's in this facility. But it has to do with his access to property. Basically, if he's on suicide watch, they take all his stuff away. which it's very counterintuitive. The reasoning is, he might be able to hurt himself with something in his cell. So he would get, a special smock. This is where they have to wear what she called the kimono. Mr. Rosie called the Flintstones gown. They have to wear the special clothing. They don't get regular sheets anymore. Most of their property gets taken away. Yeah, okay, they won't have instruments to be able to hurt themselves, but I just can't really feel like removing the tiny little sources of entertainment and just stimulation that these people have in these tiny little 8 by 12 foot rooms. I can't imagine that's really going to help somebody's mental state. I would think if you're depressed and there's absolutely nothing to do, you don't really have a good reason to stop being depressed. There's nothing motivating in that setting. So very counterintuitive from my, of course, lay standpoint, but that's the way they do it. So before he was on suicide watch, she was only seeing him once a week. So it's once he was put on suicide watch, she would see him every day. He was in solitary confinement, as she acknowledged, reiterated some of those conditions we heard about yesterday when he was changed from close supervision to constant supervision, which we did hear about a couple times. He said it really changed very little. It's just, from his standpoint, it's just a question of whether somebody has their eyeballs turned at his cell the entire time, or whether they don't, whether they might get up and leave from time to time, or, sit and draw some anime while they're waiting for the clock. Constant confinement, constant supervision is reserved for more serious, severe instances of imminent harm. When she placed him on close supervision at this time, it was because he was not developing specific suicidal ideations or threats or plans or anything like that. But he had advanced to making statements about perhaps wanting to die, wishing he would die, confessing to the crimes, and but otherwise he wasn't posing any imminent threat of self-harm. So the bottom line really was it was the fact that he started making these statements that implicated him. That's why they started watching him. So here's where she discussed how suicide watch affects the property that they're allowed to keep in their cell. So when he started off, he is his showering. He has showering, but it's monitored. He's got the toilet in his cell. He's got a safety blanket and a kimono. In his case, on suicide watch, he would still get his regular meals. He would get books. He would have his tablet, and he would get commissary because she wanted him to be able to have stuff. So this to me confirms that instinct I sort of have, that it seems like a very bad idea to take away all of the stimulus that's available for a suicidal person. She wanted him to be motivated, so she let him have more things. But in this respect, he was treated differently from the other inmates there at Westville. This wasn't a situation necessarily where he's special because he's not been convicted of anything. There was a little bit to that effect because he had the active case, so he did need to have communication with his attorneys. He did need to have access to his discovery materials and things like that. But even aside that, it sounds like she was making an effort to ensure that he was able to at least try to entertain himself during the times that he wasn't out of his cell or having contact with her or whoever else chose to lift up the little food slot and speak through it to him. So it was, she acknowledged, her decisions about suicide watch versus just not regular occupation of this cell, that is the suicide cell, versus actually being on suicide watch. That affected the personal property, and that decision was in her control. So because of that, she herself had quite a lot of control over the personal property that he was allowed to have. So also when on suicide watch, they were not given any utensils. They would be given a styrofoam tray. All of the packaging things are made more safe. So the section that we heard about the most of this form is the complaint section, and that's what includes details from her conversations with Mr. Allen. When she would meet with Mr. Allen, she would start by just asking him what he was doing. Because she was aware that he was a pretrial detainee, he had not yet been convicted of a crime. He has a standing Fifth Amendment right against self-incrimination. He's also got a Sixth Amendment right to counsel, which generally prohibits the state from being able to question him about things while he's represented, certainly on a current case. She says that she talked to him about not discussing the case. She doesn't remember exactly when, but it was early on. And so because of that, she was familiar with his status. She never asked him about his case. She discouraged him from talking about it. She, made sure that he understood, or that she told him anyway, that it was in his best interests. When asked whether he understood that it was a bad idea to talk about his case, she said, well, that depends on when we're talking about. Depends on when we're talking about. He may or may not have understood that it was a bad idea for him to be talking about the case. She described him as intelligent and that at times he was a good communicator. The way that this ultimately plays out, it makes it pretty clear that in the early days, he's a good communicator. And then once he starts his decline, his communication fails rapidly. On April the 4th, the date of this note, she says he decided to talk about his case, that it was unprompted by her. And the statement that he made was, I killed Abby and Libby. All she did was write the statement down, and he became tearful. He said that he committed the murders on his own. He made sure that they were dead because he didn't want them to suffer. He indicated that nobody had helped him and that he did it alone. He knew they were dead long before leaving the scene. Not long before, just before leaving the scene, and that his intentions were sexual in nature. He thought that they were at least 18 or 19 years old. He said being selfish, he's been selfish all of his life and a coward, so he took their lives to preserve his own. He wanted to apologize to the families of the victims, and he wished he could go back and change his actions. In the course of this conversation, this confession, he claimed that he had a sex addiction, that he didn't think he was molested as a child, but he admitted molesting his sister, claimed that he was exposed to sexual materials, and experimented with children of both sexes while he was at that age. He admitted to being an alcoholic twice in 2011, which I thought was kind of strange. This was an area where we did try to put our heads together and compare notes, and nobody got quite an exact account of exactly what she said, because it seems nonsensical. And alcoholism is typically a persistent condition, so it's not something you would be twice at any date and time. But you might be perhaps admitted to treatment or admitted to a hospital or something like that at specific times. But we just weren't able to capture her answer with sufficient detail to be able to say if it was either of those things. During whatever it was that was happening in 2011 related to being alcoholic, he was cared for by his wife. On March 21st of 2023, she reports that he found God. He asked if she believed in God, said that he hoped everyone found God before he died. He was interested in Psalms 23. I don't know my Bible all that well off the top of my head, so I gotta look it up. Which one is this? It's the Lord is my shepherd. It's the prayer. It's the Lord's Prayer. He'd hoped that he would be able to give his Bible to the families, or if not to the families, to somebody who would need help. He expressed remorse for his actions and wished he could go back and change change his actions and apologize. He was glad he had not killed himself, said he wants to see his family, hoped that they would forgive him, that he was grateful for the window view outside, and that he is happier than he has ever been in such a terrible place. When the offenders, or inmates, I should say inmates, because of course he's not an offender, but he is an inmate. When they're first screened into prison, they go through a diagnostic process. And so there's a number of screening questions and things like that that are done. Typically, a person's religion is inquired into at screening. They want to know if this is something that is a comfort to them. And Rick had not initially reported any type of religiosity. But this began to change. He was asking for the chaplain. He would sleep with the Bible, and he would express concern about her, Dr. Walla's, faith. On this note, she was looking at risk factors, and the risk factors for Rick at this point in time included legal status changes and just frustrations about his general conditions. That seems pretty routine. Like, I would think that would be nearly universal. People would have frustrations. Probably not so much legal status changes, but definitely when people first go to prison and their cases are on appeal, there's a lot of stress in the process of waiting for that decision to come down. It can take a couple of years. And so legal status changes in that respect are probably pretty common among a lot of people who are first arriving in prison. Her clinical observations that she described at this time, these are just her impressions of his behavior. He said he went between calm and bizarre, smiling. His confession was in a very matter-of-fact tone. He was claiming memory lapses. He was tangential in his speech throughout, and he was showing abrupt religiosity. So not like a gradual, maybe I should think about improving my life, maybe be a better person, something like that. I'll look into this. I'll look into this religion thing. It was like an abrupt, very quickly from zero, no real religious practice, to now being like extremely religious, reading the Bible all the time kind of situation. Her opinion, she described it as purposeful and instrumental. This is where I think we may be drawing on the notes, perhaps a little bit more than her personal observations. She thought that there might be secondary gain associated with what he was doing, and so he was potentially feigning mental illness. It was reported to her that he may have drank out of the toilet. So when she asked about it, he said that there was maybe no water. So she asked about the running water, and he said it didn't matter. His current mental status, I couldn't get the answer. As far as what it was, I don't know what the answer to that one is. This is at the very early stage of his decline. So at this point, based on her later testimony, I don't think they are necessarily looking at a diagnosis yet. I suspect their primary focus here is they're going to wait and see if he quits. If he's faking, then maybe he'll get tired of it and stop doing it, and then they can move on from there. Now, this confession, remember all these details I just gave you. She's not actually sure if that was in his first statement. She was just aware that he was making confession statements, and she was aware that he had already made a written confession to Gallipo, so to the warden. And we remember that letter he wrote from yesterday. I killed Abby and Libby. I'm ready to formally confess to killing Abby and Libby. At the time, she said this occurred. It was after meeting with his attorneys. that he began making these confession statements. His appearance, she described as within normal limits. There was nothing alarming other than a physical observation she made that his eye contact was intense. So he's like staring down, that kind of conversation that somebody is. It makes you uncomfortable, as their eye contact is really, really super intense. She said with him, sometimes that was normal, but he presented various ways over time, and that this intense eye contact was intermittent. So it wasn't a typical thing that he did. It is not anything that we saw on the interrogation videos. So nothing like that. He appears to be perfectly normal, logical, coherent, everything in all respects. As far as his activity goes, he had the ability to walk around and care for himself, take care of his own needs. So that's sort of the bar in this context. Can you walk? Are you ambulatory? And can you take care of your what they call ADLs? She'll talk about ADLs later on, but it's activities of daily living. These are things that are just sort of basic necessities that are needed to go about your life. Being able to things like brush your teeth, keep yourself clean, feed yourself, clothe yourself. And so degradation in the activities of daily living, that can be an indicator of some type of dysfunction, up to the point of what they will categorize as grave disability. And grave disability in many jurisdictions is the grounds where they start to have the right to give you mental health treatment that you may not want against your will. That's going to come up. She described him as cooperative, but he was labile, meaning his emotions fluctuated a lot. He was not in a consistent mood. His thought process she described as tangential. Sometimes he would talk about things. He would trail off. Sometimes he would come back to it, and sometimes he would not. He would just completely abandon wherever he was going. With the murder information, he relayed it in a chronological manner that she described as concise. So in the midst of all of this sort of chaotic, confused, tangential, nonsensical, intense eye contact type of conversation, like the one super sane thing he does is confess, description-wise. He did not report hallucinations or delusions. Her assessment was that his anxiety and depression had improved because he was not suicidal. Very strange finding to me. Like you just told us he wasn't on suicide watch. He was on suicide watch when he was first there, but then he got taken off and he was off it since December. And so you would think that this would be, that would be more of his baseline, and that going down this type of behavior is probably, a decompensation type of situation. But no, she saw it as an improvement because he was not suicidal. She said some things appeared questionable, but overall he was cooperative and communicative. And so ideally, they just wanted to focus on his mental health concerns, which he came into with the Department of Corrections, the depression and the anxiety. They were aware of that when he came in. So to focus on managing those and his safety. The next report was on May 2nd of 2023 when she had a visit with Mr. Allen. He was very tangential in his communication. He was focused on the same stuff, the same concepts he kept repeating. The statements that he made: I killed Abby and Libby. I will kill everyone. I will wipe out the world, the whole world. I will start World War III. Is it okay to kill myself? And he was suggesting that they should let the other incarcerated individuals in his cell to kill him. He said he did not want to die. When she asked him if he had a plan, like did he have a method, he said that he would climb on the sink. He said that he killed his whole family and his best friend, but he said he wouldn't kill himself. He is too much of a coward. Now, something I thought was very interesting here, of course, when we're talking about Abby and Libby, their position is this is a confession. But when he said he killed his whole family and his best friend, Dr. Walla thinks that this is not a confession. This is just more a metaphor. This is just him being literary in describing his feelings. So what the basis is for distinguishing between these two things, she doesn't get into that. Stuck out to me, definitely. Like, wow, that's awfully convenient, isn't it? Multiple confessions. These ones are real. These ones are not real. Based on what? They had a discussion about why he was eating the feces that we heard about yesterday. And he said, because I'm insane. And when asked again, he said, because I didn't think I'd have water. So she told him that that didn't make sense. And he said, I know. In terms of his status, he could converse and he could initiate topics. And I have a little note in my margin here, like being able to initiate a subject, even if it makes no sense at all. Like if this is the bar, it seems like, anything greater than catatonia is going to clear that in this setting. He had difficulty staying on topic, but he did not present as psychotic, which at this time in early May was an improvement on his prior condition. At this stage, there was a reference to medication. He was saying that he both will and won't kill himself, that he did and didn't want to die. And so this uncharacteristic presentation was also showing up in his behavior. He randomly asked for a drug test at one point. She said it's a randomly asking for a drug test, but we find out later on he's had antipsychotics involuntarily administered to him at this point prior to this. So I don't know really how randomly it is under that context. But that's her characterization of it. He randomly asked for a drug test. She said his behavior was improved relative to before this date, that he did not present as psychotic and that he was in remission. She described this as a brief situational psychosis. She said that it lasts for about a month. The sort of not the diagnostic criteria, but just the characterization of this specific diagnosis is that it would last about a month. It would return, and then thereafter, the person would return to normal functions. So that was his diagnosis at this particular time. He had eaten meals, he had eaten showers, and so basically, sometimes he was receptive to these types of activities, mostly at the beginning, but it showed an understanding and willingness to kind of meet expectations for normal baseline behavior. And she would like to think that the conversations that he was having with her helped with that. She did agree that might be in part because when he met with her, it was simply an opportunity to leave his cell. And we heard yesterday from the officer who testified about the triggers, that his trigger seemed to be coming back to his cell, being in the cell. That's what triggered his behavior, his bizarre behavior. So when he's saying that he will and won't kill himself during this time frame, he is on constant observation at this point. She kept him there. She was able to obtain him a tablet so that he could have regular communication with his wife. He had gotten one on entry, and according to her, he got one faster than normal, as far as what she understands the normal process is. But by this time in May, he had apparently broken his tablet. She said that the warden mentioned providing a TV to him and that she probably could have gotten him a TV, but he did not want it. So we heard some conflicting stuff about this yesterday. The warden had referred to a cardboard box in his cell that he thought was where the TV had been. But then we heard two guards saying he never had a TV. So sounds like after the time he was, severely deteriorated, they considered whether they would be able to do it. And now in that condition, he is not interested in the television. He was cooperative for the most part. So they had an addendum for his diagnostic criteria. Like she mentioned that she keeps that separate. And so his diagnosis is brief psychotic disorder. And it is characterized by the presence of one or more delusions, hallucinations, disorganized speech, disorganized or catatonic behavior. She said that he had no indication of delusions, but he had the disorganized speech and disorganized behavior. It required a disturbance of at least 1 day, but less than 1 month. So can't be just like an instant, temporary, like flash. But if it's longer than 1 month, if it's more persistent than that, then it's probably going to be something else. So the brief psychotic disorder is specifically less than 1 month. And finally, it can't be explained by some other condition, such as by drug abuse or some other psychotic disorder. So this disorder, she said, it's marked by stressors, meaning it often occurs in response to circumstances that would be stressful to anybody in this individual's cultural context. So not everything depends on your culture. Not everything is stressful to every person. But what you are accustomed to, if it would be stressful in that situation, those types of stressors would need to be present for this diagnosis to be applicable. She did not enter the specific dates, requires the month-long period. She didn't say it was from day X to day Y. She just generally estimated that it was from about the beginning of April to about the beginning of May. She said, at this point, it takes time to observe. She wasn't making a formal diagnosis at this point in May, because they have to wait and see if it's persistent. If it's persistent, then it would be a different diagnosis because it would be longer than 1 month. So also on May the 3rd, he wanted to call his wife. And at this point, they tried to help him call her, but they got no answer. And he said he wanted to tell his story. And so this is where he provided the narrative of his crime. This was confusing to me because that whole summary that she gave early on that made it sound like he said all of these things on April 4th. Now she's clarifying. It seems he didn't say these things until April the 3rd, or until May the 3rd. So well after he has been, in this degraded state for approximately a month since he started going downhill. So he said he wanted to tell his story. He had seen his parents. He was supposed to go eat, but he left instead. So he went and got a 6-pack and drank 3 of them. He finished the rest later. On the trail, he saw the girls. He followed them to the bridge. He did something with his gun and said, I think that's where the bullet came out. His intent was to rape them. But he saw a van and he got scared. So he cut the girls' necks, made sure that they were dead, covered them with tree branches, and then left, avoiding the trail so that he wouldn't be seen. He returned to his vehicle, and then he went home and went about his life for the next 5 years. All of this, according to her, was unprompted. And after he said these things, he appeared to be relieved. In the same meeting at the same time, he had concerns about his property and about not having adequate water. They mentioned safety concerns and the possibility of a transfer to another facility. The state is giving all of this stuff without filling in a lot of the context about what got them to this point, like why are they here? And so it's going to take, of course, until we get to the defense case before they really start to fill in some of the gaps here, and you get a better picture of exactly how this evolution, deterioration went. At this time, he told her that he had previously consumed feces because he feared telling the truth. He wouldn't kill himself because he was too much of a coward. But if he died, he wanted his wife to know he loved her. She felt that there was no reason that he should feel unsafe to sleep. This to me is not realistic. There's nothing safe about prison at all, like really under any circumstance. Like the very act of sleeping in a prison is a pretty good reason to feel unsafe about going to sleep. He asked for his property bag, and he had some dispute about some things apparently that he thought were missing. And she said she told him that they were not allowed to withhold things from him just for punishment, and that she wasn't sure what he didn't have that he was concerned about missing. There were some odd things that she noted. He kept repeating that he did not want to miss Easter. May the 3rd, like if May the 3rd is near Easter, that is a really, really late Easter. Like I don't remember a May Easter off the top of my head. Seems like Easter would have already passed because usually it's late March or April. I know this because I was born on Easter Sunday. The weird thing is that you would think Easter Sunday, it's based on the astronomy, the first Sunday after the full moon, first full moon in March. And so you'd think that would be on a pretty regular schedule, right? It would just recur every so often. It doesn't. It's very strange. It must be something based on our calendar system, but I was born on Easter Sunday. It was Easter Sunday on my 11th birthday, and it hasn't been Easter Sunday on my birthday since. So that's a little sideline there. Kept repeating that he didn't want to meet Easter. He was paranoid. Or his paranoia, he had paranoia, but it seemed normal. This was a strange comment. Like, I don't know what that means. Are we now contextualizing it to the prison? Like it's normal to be paranoid in prison, kind of like it might be normal to be afraid to fall asleep in prison. It seemed strange and inconsistent to me, but it wasn't entirely clear what she meant by his paranoia seemed normal. Could just mean that for him, like for his baseline, maybe that's just how he is by now. She said the information that he provided about the crime, it seemed organized, and he was not displaying any psychotic symptoms other than obviously this extremely disorganized thinking where, he doesn't want to miss Easter and so on and so forth. Strange explanations that he's giving about, not having water and stuff like that. So he was cooperative with his treatment at that point in time. And she said he was more organized at that point than he was since he was first placed on the suicide watch a month earlier at the beginning of April. She said he probably had a medication change, but she was not sure about his compliance. He had a lot of irregular stuff in his cell because he had to live in that particular cell. According to her, there was nowhere else he could have been. But he wanted to be allowed property. So he had his mattress, his blanket, his clothing, his meal property, like not the suicide risk clothes or the suicide risk sheets. He got to have normal ones. On May 5th, there was a periodic evaluation of his suicide risk. And so they did this when there was a status change. The risk factors identified were historical risk factors, clinical risk factors, situational risk factors, and protective risk factors. So a lot of things in there that aren't really in his control, that are always going to be risk factors and are always going to kind of hold out the possibility that somebody is going to be able to just say, well, historically, you had these risks, and situationally, I don't know, maybe something's going to be stressful coming up for you, like maybe a trial or a big hearing or something like that. Obviously, the protective one is always going to be the same. He's there on the safekeeping order. So the only thing that's really in his control, kind of at all, is this clinical risk factor. Basically, how is he presenting right now at this particular point in time? So it was just a thing that I noticed that, that seemed kind of unfair. Historical risk factors, it's never going to go away. If you have that, it's history. It's always there. You can't change it. And there was no indication of like the minimum number of risk factors that would have to be met before they could change his status. So at this point, they found that he was at a high risk for suicide. He had depression and anxiety. Their number one goal was safety, his safety. It's just all this safety. It just seems so, it's like gaslighty, isn't it? It's gaslighty. They're calling this safe. I mean, the man went from normally functioning to completely disorganized, babbling, super hyper religious, not sleeping. We'll get into some more of that later, but all that, and they call that safety. They call that safety because he just hasn't literally offed himself. So their main goal with treatment was to target his impression and anxiety in order to improve his daily functioning. So not necessarily so that he's happier and feels better, but so that he can go about the tough business of getting himself dressed and brushing his teeth and showering and eating when he doesn't really have any reason to, because he's stuck in a cell with absolutely nothing to do. At this point, they moved him from constant to close watch because of the improvement. And at some point in this document, there is a documentation of what his watch levels were historically all the way back to November of 2022. On May 9th, he spoke again about his case. He said he just wanted to sign, I just want to sign my confession. And she told him he had to discuss that with his attorneys. As far as his mental health improving, she said he had some thoughts of self-harm, but he was planning his last meal. But he also wanted to help others and he wanted a job. But then he would also go back to saying he'd be better off dead. So it sounds like he's still irregular, fluctuating. Don't think this is really tangential, but it's just inconsistent. She assessed him as having no psychotic symptoms, that he had mild impaired judgment, and he had some preoccupations, such as with hurting himself. She herself said she never tracked his medication, that it was actually sometimes hard for her to know. There is a record, like a nursing record, that would show basically if he was being dispensed his medication, that she could but did not normally access. And so whatever compliance she noted in his reports was probably just based on his self-report. Whether he was taking his medication or not, she would ask him, he would tell her, and that would be that. She wouldn't do any further investigation into that. On May the 10th, they met out of his cell, so down in the cubicle that we heard about. He reported he was having issues with being able to use the phone because his tablet was broken. So she had gotten approval by the warden to get him a phone to try to make a phone call. So another time they had tried it, but it didn't work. This time he was able to connect with his wife. While he was on the phone with his wife initially, she left the room. And then when he came back, he said he wanted to call his wife back and tell her that he did it. He said that I want you to hear this so you understand. And he wanted her to stay in the room for that conversation. So she heard it and she reported that he was asking if they loved him, if they would continue to love him, expressing that he might have to spend his life in prison. They might only get to see him one more time. He mentioned the electric chair. And then he said, I killed Abby and Libby. His wife said, stop saying that. And then the phone died. After the phone died, she says, Rick said she doesn't believe me. He said, I didn't do everything I said I did, but I did kill Abby and Libby. She described his interactions with his wife as pleasant and affectionate. that he remained calm, he didn't cry, he seemed organized, and there was no evidence of psychosis. On May 11th, he said he wanted closure by apologizing to the victims' families and that he wanted to see his wife. He said he didn't know what closure would look like for him. He was oriented to person, place, and situation, but he was expressing that he didn't know what date it was. So a little bit of time confusion there as far as his mental status. And then the next note in this particular exhibit jumps down to August the 3rd. This, by the way, is the point where I'm putting my notes that Nancy Grace left. This was all that she had wanted to hear, was just through that 511 note. So this is where she walks out. In his August 3rd complaint, he was saying, I wanted to go to heaven, that he couldn't contact his wife. He wanted to talk to her and to see his family. He talked about being afraid of dying. He said he doesn't feel well. He feels like his heart will quit. He was afraid that something would happen to him before he could say goodbye to his family, that he didn't want to die. He was confused and said he didn't know what was rational anymore, and that he was not sure if he was going to heaven. At this time, she said she wasn't sure if he was remaining refusing family contact. Early on, she says that he would say, I need to let my wife go, and that he was a burden. So it sounds like there was a period of time where perhaps he was trying to cut his family off, but she wasn't sure if that was going on at this particular point in time. So then we took our recess right after that. We then went into the next exhibit, which was a lot of the same information, but it's just apparently a separate set of documentation. So this was my impression, more of like her therapeutic notes, her visit notes. The first ones that we heard were the suicide watch kinds of reports, but it really wasn't entirely clear. I didn't get a good understanding of what the distinction between these two sets of documentation are. So this one is the more thorough one. His physical appearance when he came in November 2022, the state wanted us to know that he was about 180 pounds when he arrived. And his weight became a topic of conversation because he would refuse meals and he would also exercise in his room. We'd heard about him running naked, while singing God Bless America and stuff like that. I think that's the exercise that they're referring to. Maybe he exercised as well before he deteriorated like that. But just that his weight became an issue. And that refusing meals is a concern for them in the prison. And so when he was refusing meals, it was something that she would check in with him. So in the beginning, she says he was taking care of himself by exercising and by trying to lose weight, that this was a deliberate thing, that he would sometimes refuse 3 meals, but not the 4th. And that this was a distinction. This was an important distinction because you could miss up to 3 meals and it would be okay. But if you missed a 4th meal, that would get reported. At one point, he reported satisfaction with his weight loss, and he reported to her that he was exercising in his cell. So the first note that we get here from the state in this time frame is from November 10th of 2022. In this report, it says there were times when he would refuse to come out and see her. He felt that he was a burden. She told him he had the option whether to see her or not, so he refused. He seemed confused about who he should communicate with because he's still not assigned a public defender. And she told him not to discuss it with anybody. She said it is okay for him to discuss his symptoms with her and okay to accept assistance. It's okay to accept the assistance. The government is here and they're just trying to help. The next note is on April the 7th of 2023. So this is after the first confession statement that he made. He was aware that he had confessed. She told him that it was not in his best interest, and it was probably against the advice of counsel because it could also be passed on. It could be overheard, passed on by inmates to their families and or to the media. She said at this time it was more blatant, with feigning symptoms of memory loss and confusion. And when asked for an example, she said that he said, "I didn't sign anything, right?" As far as his confusion or his memory loss. So this, I think, is talking about his confession. "I didn't sign anything, right?" And she told him that he had not signed, a formal plea deal or anything like that. So she's describing kind of these details, but she doesn't really give an example of what's the indicator of faking these things. And so I wonder if this is where she is just relying on the logs. She's relying on the guards telling her he's being a pain in the butt now, remember? Because he wasn't just doing this one time. Now he's done it. If you just did it one time, you get sympathy, but you do it a bunch of times, you're a pain in the butt. And now you're probably just looking for attention and acting out. Her inability to describe something specific is what, makes me suspect maybe she's just relying on those logs for this information. Next note was from May 10th of 2023. They met outside his cell. He was sitting with his back against the wall, raising and lowering his arms, naked. He was not responding when she spoke to him. There were papers all around the cell. She received reports that he had been doing something to his penis. He may have urinated outside of his toilet. He was talking a lot about his wife. He had religious preoccupation. She assumed the papers that were all around his cell were his discovery. And she said all she really knew about his discovery was that he had it, and they were concerned about other inmates seeing it. And so that is why they removed the inmate companions. Once again, we have a conflict. We have the administrator types saying removed because of the concern about the discovery. We have the prison guards saying because the inmates were harassing him. She said that she herself never saw the discovery and that he received it about the time that he started confessing, which she would place at early April. She said that the shift in his behavior that was observed occurred after he received his discovery. The next note on May 12th of 2023, she again saw him outside of his cell. This time he was clapping, he was banging on something, he was kicking the door, and he was masturbating. The camera, according to it, he was constantly naked, touching his genitals, rolling around, refusing to wear his kimono. And that meant that he wasn't getting rec time outside of his cell because you can't leave your cell when you're naked and go down to another part of the unit. So apparently he's losing his rec time. At one point, he refused to leave the rec area. This, I think, is the tasing situation that we heard about yesterday. Wouldn't remove his hand from the slot. They couldn't close the door. And so he got tased for that. She believed at this point his behavior was instrumental for secondary gain, meaning that he was trying to get something, but she doesn't know what he was trying to get. Once again, not real sure what the reasoning for this is. If this is just something she's kind of taking for granted because the prison guards reported it in their logs, or if this is a conclusion that she reached independently based on behavior that she seems to be describing to me as a bit bizarre. Well, more than a bit bizarre. April 13th, 2023, his behavior was escalating. He was lying in and consuming his own feces, so they started looking into involuntary medication. The psychiatrist went to offer him medications on a voluntary basis. He refused them, but the psychiatrist determined that at that point, he did not qualify for emergent injection of antipsychotic medication. They changed his status at this time, his observation status, from close to constant. So no longer the 15-minute. Now we're eyes on the entire time. She noted that it was possible that he was experiencing an emotional breakdown, that it could be due to the discovery. This, I mean, one word that never came up through all of this is trauma. And it's something that I wondered about. I mean, people have varying degrees of callousness isn't the right word in this context. Insensitivity to graphic photographs and things like that we know were part of the discovery in this case. Some people would be extremely disturbed by that. I don't think we know. But I thought that was important that she acknowledged it, that, yeah, this could be, he got his discovery. There's all this terrible stuff in it. And he's having an emotional breakdown that was related to that. She thought that it was also possible that he was trying to expunge his guilt, because by this point he had confessed, or it was possible that these things were being done for secondary gain. He had had little to no sleep since April 4th of 2023. It's, remember, April 13th now, so 9 days. That's a lot of time without sleep. That is going to mess up a person's head and behavior. I feel like these 4-hour sleep nights, I'd probably lose a good 20 IQ points every day. And that's just one day, let alone over 9 with little to none. So initially his sleep was sporadic when he first came in, but then he started going a couple of days without sleep. And so she said, at this point, it really doesn't matter from a treatment standpoint if he's faking it or not, because he's deteriorating either way. So something needs to be done about it. They don't kind of stop caring about his motivation and whether he is, making himself a pain in the butt. They just have to deal with the consequences of the behavior that's presenting. Made it clear that intervention requires deterioration. There's no getting out ahead of stuff like this. There's no catching it early. There's no, preventative treatment in prison. They wait till they deteriorate, and then they go ahead and decide to do something about it. And what they decide to do about it is awesome. Really, really awesome. On April 17th of 2023, she had a daily visit. She reported he had a greasy, dirty window. He was in the middle of his cell with his eyes closed. His hand was raised like he was holding something. He was closed. He was moving his lips like he was praying. She said his name and he didn't respond. Later on, he called her and agreed to talk to her. And that she described that he was acting bizarrely, but then stops when she walked away. She's familiar with psychosis and can make that diagnosis. She said it is not completely impossible for somebody to go from a very bizarre state to okay, but it would be atypical, and that she would need more information at this point to diagnose psychosis. I thought that was a little bit strange, because how do you know he's going to normal when you've walked away? You're no longer there. You're no longer observing him. Is it like, what's our time frame here? If you see him apparently normal for like 2 seconds, are you saying nobody psychotic is ever lucid? I'm sure she wouldn't say that. That would not be correct. But this is part of the, part of the foundation for this argument the state wants to make, that he's faking his mental illness. And so part of that is because, according to her, he would act bizarrely, but then when she walked away, he would stop. During this session, he kept his eyes closed for a majority of it, but he was open and willing to communicate. He talked about having repeated nightmares and dreams where in them people would die due to his selfishness. He would say that he wanted to tell the truth, that he lied so much, and that he felt separated from reality. She describes him as coherent about sharing his thoughts and concerns. He said that he wished he had a medical illness because he had done some vulgar things that, and that wasn't him. I think we're talking about the feces at this point. So he wished basically that he had a physical condition that he would be able to attribute that to, brain tumor or something like that. The dream he described was that he fell asleep. If he faked his death and the world ended, if he fell asleep and died, and that activated a nuclear war after his death. So she's just describing this is reflecting very disjointed thoughts. They would seem rational at first, but then he would trail off, or he would go somewhere and not be able to reach rational conclusions. During this visit, he was singing, marching, crying, blaming everybody else. And according to her, these things, they seemed organized. This was after he had gotten involuntary medication, April the 17th. This is after he had gotten the involuntary medication. She thought that he was showing some improvement. He did not have hallucinations, but he still had grossly disorganized speech and thinking. So at this point, they are at the rule out stage with the brief psychotic episode diagnosis, because it hadn't yet been a month since he started having symptoms. April 21st, the note simply says he was engaging in bizarre behavior, and she did not believe it was genuine, meaning beyond his ability to control it and not engage in that behavior. No further detail. Don't know if this is her personal. Don't know if this is based on reports that she's getting from the prison guards. April 25th, he said that he had been struggling longer than he had acknowledged with his mental health issues, but he had never experienced anything in the past like this. He mentioned that maybe he was not taking his meds, which apparently Prozac he mentioned, and also Seroquel. He spoke about wanting a transfer. This gets then, highlighted as possible secondary gain. You can't be mentally ill and want something. You can't want something if you're disturbed, or you're probably faking it because you're trying to get something out of it. Other secondary gain was that he wanted visits with his wife, in-person visits with his wife. She said that she advocated for in-person visits with his wife, and she was ultimately successful. That was not typical for the WCU. This was a special accommodation for him. One visit happened, and ultimately they figured out a second one later. So we don't know exactly the day that this visit happened at this point, but April 25th didn't happen any sooner than that. So he's gone 5 months. 5 months without having any in-person contact with his wife. Okay. This is not only a big difference from jail, it's a major difference from jail. Like jail, you can often have visiting every day. But even prison, if you're in general population, you're not in some kind of close, confinement situation. You get visitation. You get in-person visitation. You might have specific days, depending on your security, your risk level, your job, things like that. It's not likely to be the everyday level like it can be in jail sometimes. But you're talking usually at least once a week, maybe twice. You can have in-person visits. So this is a big red flag for me with him being in the hole, being not convicted of a crime, and the fact that they had known that his family is this trigger. They already, before he even got arrested, they're already trying to play his family off of him. They're bringing his wife in to try to, turn them against each other, try to play them off each other, and do it in a setting where it's recorded so they can go back and watch it. This was all very, very disturbing to me because it is so abnormal. And your right of association and your right of those relationships with a spouse and stuff like that. These are fundamental rights. These are fundamental rights. We know that from Obergefell, but we knew that before. Your right to have, a romantic connection with your partner. 5 months with no contact. That was very sad. On April the 28th, she reports that he was lying in his bed naked. He said that he had to shower first before the session, but she told him that he didn't have time. He had not showered in the pod, and she noticed that there was a smell coming from his cell. She took this as a positive, that he realized that he wasn't okay to be able to come out of his cell. And so this showed improved insight. These notes are like, they kill me. I'm an optimist, but like, this is over the top. This is wild. This just seems overly rosy for a man who is in really, really bad shape. He has improved insight because he knew that he stunk and shouldn't come out for his shower. When asked why he wasn't taking care of his activities of daily living, he said, "Because I'm selfish." He did say that the visit was important to him, and she wanted to have the visit to try to help motivate him to take care of himself. He went on, according to her, this is her words actually that she used. He went on about, I was like, is that therapy speak? He went on about, that sounds pretty judgy. I'm pretty sure that's not the attitude you're supposed to have about the things that your client is telling you in what's supposed to be a therapeutic setting. He went on about flushing the Bible down the toilet. He didn't have God. He didn't have food or water. She said it was not true about the food, that would just mean that he was refusing his meals. Water, this drew no objection. It could have. It's very speculative, or the facts not in evidence or something like that. She said water could be shut off if he was flooding his cell. It would just be temporary, but that would happen from time to time. He was not deprived of food or water for punishment. They don't do that to their inmates there. Bet they don't. He didn't seem psychotic, but he seemed, what she said, this is not a good word, but it's a word that she used. He seemed gamey. And I think she's referring to his smell. I don't know. That's what I think of. If I think somebody seems gamey, somebody smells kind of gamey, they're kind of ripe. She said he was maybe severely depressed. But it appeared to her that his behaviors reflected a secondary motive. So here we are still with the feigning. And as long as you want anything, have any desire, you would think wanting something would be motivating, right? Like it would be good if you're somebody who's prone to depression. It would be good for you to want things, because I think that tends to be a pretty common experience with depression. You stop caring about anything. You don't want anything. You can't be bothered to care about wanting something. So actually wanting something is motivating. If you're depressed and you're lying in bed, but you want to pet your dog and your dog's outside, that can motivate you to get up and go outside and pet your dog. And that's right there one of the reasons why, I think animals are such a good protective factor against severe depression. Wait a sec. At this point, This concludes her testimony on direct. So at this point, we're at about 1:15. There was just an interesting little sequence of events that happened here where Mr. Rosie asked for a sidebar. So they go up to the bench. It's a very quick one. And I see Judge Gohl and then they look over at the clock. So I know right away we're talking about are we gonna take the lunch break? And the answer is no. When we come back, we're going forward 15 minutes. It's going to proceed and go forward. So he revisits her background. She's a psychologist. She went to a professional psychology school. She had been in the Department of Corrections since 2018. She's not a specialist in any area. She's just a general clinical psychologist. And he elicited that she is not working in the Department of Corrections anymore. We established that she gave testimony in a deposition in July 31st of 2024, and that after that day, she was not allowed to return after that point. She said that she was still employed by her same employer, this centurion, but she is now at another facility. Here's where things got a little nuts. I sat through this direct and, I can sit and nitpick it, but in real time when it's happening, it's like, ooh, this doesn't sound good. This doesn't sound good. This is a professional worker, not just some inmate, not just a guard that doesn't have any training. Like, this is a highly educated, licensed professional. She's going to have some credibility because of that. She's going to have some weight when she's saying things like he's faking mental illness. Like, that's going to mean a lot more than some type of untrained lay person just saying, well, he was being a pain in the butt. And so I just figured he was trying to get attention. And then there was just the detail of that confession. It was very, very detailed. And so, and it included that extra little bit of information about the van, kind of filling in why things unfolded the way that they did. So we finished her testimony, and I'm thinking her direct, and I'm thinking, this was bad. I don't know how the defense is going to address this. How are they going to handle it? Where it turned out, it seems like it wasn't really that difficult to handle at all, because I was not expecting to hear that besides from her treatment of Richard Allen, she had personal familiarity with the case circumstances, because she had followed the Delphi case on podcasts and on social media, both before and after Mr. Allen. Before treating him. She was purposefully seeking out information about the case. She continued to, her interest continued to grow as the case proceeded. So at one point, he's a little bit ambiguous about this. At one point, there were significant activities in the case that didn't involve Mr. Allen. Pretty sure he's talking about third-party investigation stuff, Frank's memo stuff, third-party culprit stuff. And at that point, she decided that she would use the Department of Corrections resources, their private access, to be able to get information for her own personal reasons. She thought that was probably in violation of Department of Corrections policy, acknowledged that they had to do investigation over it, and that she had gotten non-public information. Guys, stay out of the databases. Like, some people can't be trusted with access to a database like this. My first access to a database like this I got when I was like 20, 22, 23. I was working as a court clerk. I was a court clerk in the courthouse in South Lake Tahoe. I did jury stuff, but you also do just a lot of data entry. It's a lot of data entry, just putting things putting information in different formats. And so through that, I would get access to things like criminal history records. And it was like a, regular thing that there would be turnover because somebody just couldn't not get into the database to look up their boyfriend, their babysitter, their parents, their enemy, the person that they argued with, on social media. I mean, not actually, there really wasn't social media too much back then. That's how old I am. But you get the idea. Just couldn't resist it. You guys, they're gonna find out. They're gonna find out. Like they have logs of your login and what you search for. So they're gonna know if it's not related to your work business. Just word to the wise. You get access to a database like this, don't use it for your personal business. You will get caught and you will lose your job. And you'll be lucky if you don't, potentially have worse consequences than that, depending on what database it is that you go in and access. She acknowledged that she followed several specific podcasts, including True Crime, Gray Hughes, Defense Diaries, Criminality, some other YouTube channels, Prosecutors podcast. She followed it online on a variety of settings, Facebook, and she was contributing at one point about how to, where to get information about the case, and that had happened just earlier this year. When asked if this is a violation of the APA guidelines, the American Psychological Association, she said it was a gray area. Well, color me skeptical. I'm inclined to think it's probably not much of a gray area. After Richard Allen was arrested, she was even more interested. And her work at that time, she lived in south of Chicago. So she had a commute that was about 1.5 to 2 hours every day each way. And she would use that time to follow this online content about the case. Eventually, somebody pointed out that she was following all of this. Like somebody figured out who she was online and pointed out, maybe you shouldn't be involved in all this stuff. And so at that point, she shut all of her accounts down, acknowledged that a lot of content was consumed. When asked about whether she disclosed to her employer about her personal interest in the case, she said, "We did when he came into the facility." This answer changed. This answer changed actually a couple of times. But the first time she's asked, she said, "Yes, we disclosed that when he first came into the facility, that I have this personal interest in the case." Well, Mr. Rosie starts turning to her depot at this point. The sign of a really good cross-examination is when you are able to get to the point where you can train the witness. All I have to do is, pick up, glance at this deposition, just mention it. All I have to do is get it on your mind, and you will go ahead and give me what I want, because that I'm going to be able to back it up with whatever I put under your nose. So there's no point in fighting me. That will just make you look worse. Mr. Rosie began the steps to get that established at this point. So during this deposition, at that point, she said that she never reported her interest to her employer. Well, she qualifies this now that she just meant that she didn't do anything formal to report it. Like she didn't file something formal, or I don't know exactly what she means, what a formal report would be of something like that. She said there were conversations. Mr. Rosie points out that when Richard Allen was being treated, when she took over his treatment, she also said no. She hadn't reported it to the employer. At the time, she agreed that she was under oath, but she was thinking more about a formal report when she gave that answer. When she said no, she never reported it. She also said she was refreshed recently about conversations that she had with supervisors. and that she was just wrong because she was, her previous testimony was just wrong because she had been thinking about it in a different way. Well, refreshed recently about conversations with supervisors, I did find that interesting because it just makes me wonder how that would have taken place. I mean, it could have been just with conversations with the prosecutor, with witness preparation, if they knew or they'd found a reference to it somewhere or something. But being refreshed recently, this sounds like again a deposition or being in trial or something like that. So potentially some other legal process where this came up. She said that she conceded that the appropriate thing to do, if she was doing it over, she would stop following the case while she was treating Mr. Allen. You think that might be a good idea? She also conceded that she shared thoughts with Rick about the content that she was seeing, including about pretrial hearings, that she communicated about things that she was following while she was treating him. That seems really, really, really bad to me. I'm not a licensed mental health professional or anything even approaching it. But that seems really, really bad to me. That is her own personal interest that she is allowing to interfere with this therapeutic relationship. Your focus needs to be on your client, not what you're trying to learn. Not what you're trying to learn. Or trying to influence. Trying to influence him maybe and what he's going to do. This is just disturbing that she would talk to him about what was going on online. No wonder the guy's stressed out. She said that her first contact with Richard Allen was in November of 2022. At the time, he was depressed and anxious. At first, when somebody is admitted to Department of Corrections, they go to, we talked about the RDC, which is the Receiving Diagnostic Center. That's in Indianapolis, that most people stay 2 to 4 weeks there. At this point, there was a little exchange. So the state objects a lot, definitely relative to the defense. The defense really hardly objects at all. But the defense objects a lot, and they have done it with Mr. Rosie. And it seems like, my impression of what they do is that they're kind of just trying to shake him off his game, get him distracted, get him confused a little bit. There have been some objections about, particularly with dealing with impeachment. They keep accusing him of impeaching the witness improperly. And it's driving me nuts because he's not impeaching the witness improperly. Mr. McClelland even said something about it yesterday. He kind of gave a little speech about how, for proper impeachment, you have to go and refresh the witness's recollection. No, these are two separate things. These are two very separate things. Refreshing somebody's recollection is specifically when they say they don't remember something. So they express a lack of memory, and that is what allows you to then be able to show them something and see if that will jog their memory, and then they can testify. So when they're refreshed, we're not getting the contents of what is used to refresh them into evidence. It's typically you read it silently by yourself, and then when you're done, look up. And then, does that refresh your recollection about what you said on XY day? Yes. Go ahead and say what it is. So it's not about getting that substantive piece of information in the record. It's about whatever you need to do to jog that witness's ability to testify independently. Impeachment is different. Impeachment is they deny making a statement. You ask them, did you say something previously and they denied it? Then you get to go in and confront them. You get to go in and confront them with it. Another example, another opportunity is impeachment with statements. They say something at trial, they testify at trial, and they said something differently on a different occasion. You get to impeach them with a prior inconsistent statement. And so with a prior inconsistent statement, there's a specific process to do that. You have to present it to them so that they have an opportunity to explain the context and decide basically if they agree or disagree with it. This was something that I saw Alex Spiro do in the Alec Baldwin trial, and he was really a master of it because we would just basically ask them, do you recall saying XYZ? And they would say, maybe, I don't remember saying that. And he would say, do you deny it? And it was this great method of being able to distinguish right away between what do I need to do here? Do I need to refresh this person or do I need to impeach them? And so if they'd say, oh, no, I'm not denying it. I just don't really have a clear memory. You'd say, oh, well, would it refresh your recollection to go in and look at this deposition transcript? And they would, and you'd go that way. If they'd say, yes, I deny it, then they'd say, well, do you remember taking a deposition back on November, whatever? Yes. And you're saying you don't recall at that time saying, whatever it says in the deposition. You say no. And you get to confront them with it. And here it is. So you agree this is a deposition transcript. Technically, another piece of this too, you really should admit the deposition into evidence, or at least the page where they say that thing, because that is now the statement that is what you're wanting. You're wanting the jury to focus on. So if you're able to do that, if you can do that, like that would be ideal. You can't always do it though. But the bottom line here is that yes, you have to present, if you're impeaching, you have to present the witness with their statement. And so Mr. Rosie has seemed very confused about exactly what he is supposed to do to impeach a witness for very understandable reasons, because they don't seem to know what to do. The explanation that Mr. McClellan gave is just flat wrong. Like, these are two unrelated things. They can be related to each other, but they're not necessarily related to each other. And all he's getting from the judge is just, well, you're allowed to impeach, but your impeachment is improper. He's being like, I'm trying to impeach the witness. And she's like, you have to do it the right way. He is trying to do it the right way. Like, what do you want? This is crazy stuff. So anyway, he's kind of figured out a middle ground where he's basically just doing it the way they want. They object. He like, fine, would it refresh your recollection? And they go from there. Anyway, at this particular point in time, one of the objections that Ms. Diener was continuing to make, she would object to leading questions. So when you're on cross, you get to lead the witness. You get to put words in their mouth. When I was taking trial practice way back in the day, I even remember the professor of that class told us specifically the characteristic, the thing to remember about cross-examination is it's your turn to testify. And that's really what it is. You're taking your facts, whatever evidence you have, your information, and you're confronting that witness with it. If they object, object to it, deny it, contradict it, then you have it there that you can impeach them with it. If they agree with it, then great. You've gotten the facts that you want in the case admitted into evidence. So it really is your turn to testify. And it's not that unusual to ask questions like, do you agree that? We had a lot of issue with this. Do you agree that? And you just put forward a proposition, or you can even just say, you thought he was faking it, didn't you? You have to find a way to put a question mark at the end. But ultimately, you're saying you're faking it. You said he faked. You said he's faking it. So she's objecting to him using these leading questions because she's saying he's testifying. No, he's asking leading questions, which you get to do on cross-examination. So at this point, Mr. Rosie responds, I'm trying to educate the jury, about just the intake process and what it's like. The judge says it's not your job to educate the jury. He works through it. I mean, they figure out where to go. So acknowledge that he was assessed there. And while most people in the RDC, they're there for about 2 to 4 weeks to get assessment, Rick's was a day. He was assessed in transport within a day or two. So it was very, very expedited. When she gets the assessment, she reviews it and sees if she sees the same things. So she says she is always assessing when she's in the presence of the client. There's no testing component to her assessment. They do no mini mental examination, and they don't do any objective testing because they don't have resources. So for example, if you suspect something like, I don't know, like a personality disorder, there are instruments that you could use. The MMPI is like very, very, well-regarded tool, all kinds of different psychological conditions. But they don't have resources to do that in DOC, so they don't do objective testing. They just go by what the clinician thinks. She said she did say that sometimes she would bring up sample tests. If she had sample tests because they didn't have resources, she would bring those up and use them. When he landed at DOC, we had some inconsistency on this also. She said when he landed at DOC, he had a major depressive disorder diagnosis, that it was part of his psychiatric history. At some point in here, he's asking a do you agree? And it's objected to that, as we've seen a million times. The court isn't letting him say, do you agree? So he instantly changed it to, is it accurate? And he only had to do it, is it accurate, a couple times before she realized, okay, he's able to make that switch now. And so when he starts asking the do you agree questions, she stops objecting to it. So he's going to be able to fix it. And honestly, these are the types of little ticky-tack things that really just make you look petty in front of the jury. They look so petty. These technical objections that are so easily cured by just saying your questions slightly differently. I feel like that's the kind of thing that's probably really annoying to most lay people. Like they know what you're getting at. And a lot of these objections, honestly, like they shouldn't be getting sustained, but whatever, they are. She did say that the major depressive disorder diagnosis might not have been noted in their system, but she said she herself recalled noting depression and anxiety. He was taking medication, so it's possible that he was in good shape. She knew that he had visited an outpatient clinic. Mr. Rosie says, and isn't it true, he may have suffered from a dependent personality disorder. At this point, Ms. Diener objects again. He's giving information to the witness. This is not an objection. Like what rule is that? What basis is it? Can you cite a case for the giving info to witnesses objection basis? It's just there. She's just using these speaking objections. It's getting worse. Like as the trial is going on, the speaking objections. Rosie's like, it's cross. It's cross. Get to lead, get to point stuff out. Judge Goal, it still needs to be proper. Rosie's like, it's leading. It is proper. It's leading. I've made my ruling, Mr. Rosie. It's sustained. So he slightly rewords his question and gets the same result that he would have gone without the objection, that he may have suffered a dependent personality disorder. She said that he later demonstrated characteristics that were consistent with that, particularly relating to his separation from loved ones and specifically his wife. I don't know much. I mean, I've heard of dependent personality disorder, but I don't really know anything about it. Just kind of based on the way that personality disorders are in general, I would assume that it is some kind of like an attachment related kind of problem, that he's very insecure without like having close contact, close attachment or something like that. And to be a personality disorder, it's not, it's got to be to a severe degree, to a point where it's causing you some kind of distress, like severe distress. So that's like the general ballpark of what I understood her to be talking about. And I found that was a little bit interesting, because the fact that he brought it up, I wonder if that's something that they're going to get from their own mental health provider. Just maybe there was a reason for bringing it up. I mean, she hadn't brought it up. He asked if Mr. Allen was fragile when he landed at the Department of Corrections. The state objected to that. That language. He's like, she's an expert. She can testify to his condition at the time. Pretty sure he did get allowed to ask this one. So conceded he was fragile when he landed at the Department of Corrections, and that he had been accused of killing 2 girls. So we revisit now the circumstances of his cell, the fact that it remained generally unchanged for about 13 months. He didn't get out. He didn't get out of that cell except for his rec time and his counseling sessions. Rest of the time, he's in that cell. The lights were on all the time. She said she thought that he would be able to dim them a bit. Well, it turns out that she said in her deposition that he did not have the ability to dim the lights. So he's just in there getting his circadian rhythm completely messed up because the lights are on 24/7. He's got a camera pointed out at him 24 hours a day, which no other inmate in the pod has that. This is only the suicide cell, and so it's only Richard Allen who's getting this specific deprivation of privacy that nobody else is having to deal with, even though they are the ones that have been convicted of all the serious crimes and he has not. He was watched by somebody in the control room all the time, and yet she never requested to look at any video of his cell. Now, wasn't this a compelling piece of information? Because it really just substantiates to me that a lot of her opinions about his behavior, they're just secondhand, maybe even thirdhand. She's getting these logs, and she's deferring to their report and their opinion about it. She could have gone and checked for herself, and she never did. She's going to opine that he's faking mental illness without ever actually going and viewing the behavior herself when she has the opportunity to do that. That was pretty wild to me. She said, well, if she happened to be in the control room, she would take a look. She would take a look at the camera, at the footage. I wonder how many times she actually ends up in the control room. I can't imagine there's a lot of clinical psychology work that needs to be done in the control room in the prison. Wonder how often she was in there and what her business was there. So in 13 months, she never went to look. And now she realizes, the deposition is her enemy. And so she's like, I told you in the deposition that I didn't. She agrees there is no cell more secure in the entire facility or more restricted in the entire facility than the one where Rick was held. He suggested that there were other housing options, for example, in the infirmary. The infirmary, she agreed it had larger rooms, it had a bathroom down the hall, and she said the problem with that was his level. And I think by this she means his security level, because they wouldn't let him out where he might potentially have contact with other inmates. There was also his mental health code that he had when he was classified. She acknowledged that when he was classified, meaning in the intake and the diagnostic process, he was classified as a D. She described that there are 5 codes, mental codes for just status, and that they are on a continuum of severity. So E is the most severe. And They have an additional category now for substance abuse that is F, because they had a little bit of back and forth about, well, is there an F? Is it A, B, C, D, F, or like what? So we clarified A to E, standard codes. E is the most severe. F is the separate substance abuse category that they added in. So bottom line, as a D, Rick was a 4 out of 5 in terms of severity of his condition. She knew that he had a serious history of mental health issues. In fact, because of his code, it was because of his code status that her weekly meetings with him were required. So the weekly meetings were typically held at his cell. It was only once a month at this point that it would be out of cell. So remember, think about that. This is one of the only opportunities he has to be able to get out of his cell. And he gets it once a month. He gets it once a month. It's just wild. Just wild. Suicide observation required the daily observation. So once he got put on suicide watch, he would require the daily observation. But it just meant somebody from the mental health team, not necessarily her. She said that it was her exclusively for a few weeks there, but they ultimately opened it up to others. And to conduct this observation, this meeting, whatever you want to call it, somebody would just go up to the cell and they would open the crack in the door and they would talk. The lunch slot. They would talk through the lunch slot. Remember the Rosie asking about lunch, because he knew this was going to take time, and Judge Gold didn't want to do it at 1:45 for 11:45 for whatever reason. So instead, she decides now is a good time. We're going to interrupt him in the middle of the cross, and now we're going to have lunch. Like the whole reason you give the judge a heads up, it's like a courtesy thing. It's not just for her and for everybody else, it's for the jury and their attentiveness and not getting distracted in the middle of it, so they can just focus on the whole thing until it's done. When you disrupt the cross, that can be confusing. It can be difficult to remember where you left off, all that stuff. So it's usually a courtesy to go give the heads up to the judge that, hey, this is going to take a while. We seem to be at a good point. Wouldn't it be a good idea to take lunch? And most judges are reasonable about accommodating that, because most judges are reasonable people that don't just have some issue. I don't know what's going on here. Like, why is it so bad to have lunch at 11:45? It's fine. It's totally fine. When we came back, we turned to the discovery. So Rick received his discovery while he was at Westville. She agreed that that's what she had remembered or suspected of being the documents on his floor that she observed on his floor. And she thought that he had probably received them in early April or late March. There were references in the notes to inmates having seen the discovery. Talked about, for the jury's benefit, exactly what the discovery is. It's a culmination of information about the case, including police reports and investigative materials. And she understood that he received a large portion of that in early March or late April. This is a bit of a problem for the timing of these confessions, because the alternative explanation for all of them, as far as insider knowledge, is that he got it from the discovery. Once it's provided to him, he knows the details that the killer would know. He knew those details if they're there in the discovery. So we've really taken off the table his ability to provide like distinctive details about what happened to really substantiate these confessions. She said again that she did have knowledge of his major depressive disorder. There is an intake document that she completed back in November of 22, on November 18th of 2022. And in there, she noted diagnoses of generalized anxiety disorder and major depressive disorder. He also described symptoms that were consistent with those. She acknowledged that his circumstances were significantly different than the other inmates because he was a safekeeper. She called him a safekeeper, and he had no criminal history. Now, she said we've had safekeepers, but it's not common. And this was a little surprising because we wondered, everybody else said this is like they've never heard of this before in the entire state of Indiana. A guy being held in this unit on pretrial. So she does say there were a couple in general population. So they didn't stand out unless they were on suicide watch. So I think what she's saying is that there have been a couple in the entire Westville institution, but not any that have been anywhere near on the level of restriction as Richard Allen, which in a way, frankly, makes it worse. It kind of makes it worse because one, it shows that you can keep people safe in the general population when they're on a safekeeping order for pretrial. But also because it just shows how differently he was treated from anybody else coming in on a safekeeping order. Why did he get singled out for this enormously harsh, punitive looking treatment that he got? She recalled one other inmate, but he had been convicted apparently of heinous crimes. At this point, the state objects to relevance. Rosie is saying this is going to the uniqueness of his circumstances and how that would affect his mental health. That was objection was sustained. These relevance objections are just like way off in my mind. Relevance is such a low bar. Of course, his state of mind is relevant. He goes to talk about the inmate orientation, that she is aware that there is one, and he asked about her belief in its purpose. At this point, there's an objection, foundational, establishes that she herself never attended this training and she doesn't really know, what the training is. So the objection about that is sustained. He doesn't get to ask her about the orientation. What he's trying to get at when he's introducing this is that there are certain rules of prison, both informal and formal. So he's basically stuck then with talking about the formal rules. Everybody knows there's informal things when you're dealing with inmates. They have their own code. They have their own system of what's allowed and what's not allowed and what the enforcement is and all that stuff. But she is not going to be the witness to be able to talk about that. But she does agree there are lots of rules in prison, rules for the showers, rules for the tablets, rules for rec, rules for food, rules for commissary. And she agreed that rules are stressors. Rules can be stressors. And you're like overwhelmed with all these rules and you're trying to walk the line. That can be a stressor. There's different monetary systems, This is not, you don't have a cash or card system like you have out in the real world. They have their completely different monetary system. They have special things, arrangements for phone calls, special systems. And then the fact that different institutions often have different rules. All of these things can be stressors because especially in prison where you might get tased, if you're not compliant, not following the rules, you're going to be worried about, do I know everything? Am I breaking anything? What if I accidentally, yes, of course, those rules can be a stressor. And she agreed that in this particular case with Mr. Allen, all of these rules and these changes were in fact a stressor. They talked about the TV again, and established that when a person is on suicide watch, typically they would be stripped of all of their property. So now, once again, I'm not sure if he had a TV or he didn't have a TV, because I first thought he did, and then her direct made me think I didn't. But now it sounds like he did, at least for a little bit. But then they took it away when he was on suicide watch. They also on suicide watch limit rec, limit rec time if they think it's going to be a danger to self. Isn't like exercise, physical activity supposed to be protective against depression? Like, this is so counterintuitive. So counterintuitive. I mean, it's not much, this rec cell, but they got a pull-up bar. You know, they got a pull-up bar. We know they got a basketball net. Something to do, something physical. And you take that away because the person is suicidal. This is just bizarro world for me. This is where we talked about how on suicide watch, you have to wear the kimono, which someone else referred to as a Flintstones gown. The state objected to this. They're very, very annoyed. But Mr. Rosie points out that somebody else, it was, one of the witnesses yesterday, referred to it as a Flintstones gown. Must have been one of the ones I couldn't hear because I would have remembered that for sure. That is very descriptive. That it can be stressful to adjust to wearing one of those because you got to figure out how to not have, your junk hanging out all the time. And so Rick would have been dealing with all of these things. We then turn to the notes. During the cell visits, she would produce notes. He would be pulled out of his cell to over where she is. We revisit like the structure of this cubicle that she called it, and that it's graded. So they talk through a screen. She described at first, remember, that he would be unshackled when he goes in. Mr. Rosie was contesting with that a little bit, but she describes it as you would go down the hall through the gate and close it, and then you yourself are on the other side of the gate, on the other side of what she agreed was a cage. Agreed that it was maybe a 3x3 space. Like, imagine being so desperate to get out of your cell that you would go sit in a smaller space in a cage just because it has a human being on the other side that you can talk to. She agreed that this was not a therapeutic setting, but it's all they have. There's that attitude again. Well, it's prison. It's prison. It's not therapeutic at all. This whole like mental health thing is a complete farce. It's a total farce from what I'm seeing. But it's prison. Normally, therapy would be in a more comfortable setting. And prison, yeah, can be a pretty harsh environment. So she thought that they unshackled him during the counseling sessions. And she described it as during transport, he would have them on, but then once he would get in the cage, they'd take them off. Do you remember your deposition? So at that point, he's doing it right now. Do you remember telling me that at all times he was shackled? She says, I don't remember saying that. So now she doesn't remember, gets to go refresher. Here it is. Does that refresh you? Oh yeah, it does say that. And he described those as waist shackles and box cuffs. And she just said she really didn't remember. She really thought that it once he got in, it was unshackled. But nevertheless, that's what she said under oath last time. He asked if she had seen videos of Rick being transported to court hearings. These videos were part of, you could see it online when he was going to court. Several times he got captured in his jumpsuit, in the shackles. And she's a true crime junkie, so you think she's probably seen it. But she said she had never seen anybody being transported out of the facility. At this point, the state objected to this line of being beyond the scope. Transport is not related to the facility conditions, so it's outside. It's sustained. This is so ticky-tack. With what's in the scope, what's not, what's relevant, what's not. She agreed that transport could affect well-being, and Rick reported that he was transported in a van and that he had to get into a dog cage in the van, and that's how he was transported, and that it wasn't a pleasant experience. Yeah, I wouldn't think it would be. So then we started to go through her suicide monitoring sheets, and this time we got a lot more, and we got the stuff that the defense wanted us to hear to put in context what the state had elicited on its direct examination, including all of these confessions. So we start with November 4th of 2022. Where he reported that he was doing okay, said that he was frustrated with inmate companions asking him questions. So the people that are there to supposedly monitor him and keep an eye on him and are under a rule to not have communications with him, they're asking him questions. And you got to think probably about his case, because that's why he's frustrated with it. What are you supposed to do? What are you supposed to do? You're captive. You're captive with these people. Kind of hard to be real evasive in prison when you're stuck in a cell and somebody is outside it staring at you for 24 hours a day. Asked if he reported suicidal ideations. At this point, there is another objection. So they go to a sidebar. It's a fairly short sidebar, but when they come back, Rosie is kind of starting to work with the paper, and it becomes clear from this she's objected to the foundation. It's not clear that this is a document that the doctor would have been familiar with. So Rosie's looking through the document, and he's starting to ask her about who prepared it, and then he sees, oh, actually, look at it right here. Your name's right here. You prepared this report. So it seems pretty clear. And he gives a very, very hard look over at Stacy Diener. And so Stacy Diener ends up coming over like to where the witness is sitting up at the stand and looks at what she's looking at and looks at the thing. And he's like staring hard at her the whole time. And then she goes back, my apologies. So apparently she had represented to the court that this was not the doctor's note. And so there was a foundational problem with it. Maybe she shouldn't be allowed to testify about it. So that didn't work. Mr. Rosie was not pleased with all of that. And I don't blame him, because these attorneys have been accused of being dishonest and being misleading and being unethical and all of this stuff. And if you do something like that, you need to be careful about the kinds of claims that you make to the court. On that note, he reported no suicidal ideations. But remember, he was brought in on suicide watch and was there for the first month. He was struggling with worries about what others thought, and that was related to dependent personality disorder. Now, I thought this was weird because, remember, she said she didn't diagnose that or anything. So maybe it was a rule out. It's hard to say when we can't see these whole documents for ourselves. Could be that that's just something she's testifying to now after the fact. In hindsight, that could have been related to dependent personality disorder if he had it. He also complained about the time and adjusting to the safety plan. On November 7th of 2022, the notes says basically they're going through their own intake there at Westville. And so part of that intake includes a history of physical and sexual abuse, and there was none reported. So he's now going back to rebut those statements that if you don't know that it's common, to have these types of delusions when you're in a psychotic state, that everybody under the sun has molested you and you've molested other people. There's often just a lot of sexualization of that type of thing. You might think he was like literally confessing, to like some pretty bad stuff. But when he comes in, he has reported none. Other times that he reported abuse that you noted in the reports, those were inconsistent with his initial assessment. It also, in his initial assessment, noted a history of mental illness and that he had been institutionalized. He'd been hospitalized back in 2019. So this now takes me back to that interrogation video, because that was when Mullen said that he had talked to his wife and daughter, and they knew about this prior incident. And Rick got very upset about this. I mean, understandably, he got very upset about it. He says, I wasn't going to shoot myself with that gun. It was a cry for help. I know how guns work. So I would strongly suspect that those things are related, and that, in fact, Mr. Mullen did not find that out by asking his wife and daughter. He hadn't talked to them. I would bet anything he hadn't talked to them. He went in and got the record. He got the institutionalization record. He talked about how once Rick Allen came back on the radar and they saw he placed himself at the bridge on this time, now we're going to go dig up information about him. They went and found his car, made a big deal about it being parked back in at the CVS parking lot where he works. Take a picture of his car so they can go compare it to the Hoosier Harvest Store video. Wouldn't surprise me at all. This is where they got it. They ran a background search on him and they found it. They found he had this record, and then they lied to him about where and how they got that information. So that little piece that came out, I made that connection right away. April 7th, we now skip forward to that. So the initial notes are mainly just intake. Now we skip forward to the April 7th suicide monitoring report. In that report, he noted that he was hearing things he was not used to hearing. She agreed that those things were noises and things that inmates were saying. So people are saying horrible things, it sounds like. He said he was already stressed about what had happened to him and about whether he would be in prison for the rest of his life. That seems like quite a legitimate fear for a man in his situation. On April 9th of 2022, he complained about things that people were saying. They were taunting him, calling him baby killer, telling him he should kill himself, and that this was a constant theme throughout his stay. So that's noted in her records as well. On November the 10th of 2022, he reported saying that he thought this was a psychological game meant to tear him down. That seems quite insightful. Quite insightful. Psychological game meant to tear him down while he is in the middle of being torn down. April 21st, 2022, he felt as if he were being treated as if he was already guilty. He didn't do it and told investigators he didn't do it. He would never be okay with being in prison for something he didn't do. This is after he's made all of these confessions. To me, this is, I mean, again, I want to qualify. I'm very much a layperson. I'm not trained in this stuff, but I get exposed to it an awful lot. And one of the things that comes up a lot with psychosis is that you can have periods of lucidity. It's like you don't have to be like delusional, off your rocker or whatever all the time. It's not that uncommon to have periods of lucidity. So yeah, he's already confessed, but now he's asserting his innocence. So it's a real back and forth. This, you want to talk about secondary gain? We've been talking about maybe we should be looking at this. Maybe we should be looking at these confessions in terms of secondary gain. What's the motivation for that behavior, that confessing behavior? On April 22nd, he reported that his trip back to Delphi was draining and scary, that he was sitting in a box. This was presumably the dog box that he referred to being transported in. He said it was good to know that the evidence didn't point to him. On April 25th, he consistently presents as selfless when it comes to his wife and family. So he's clearly preoccupied and nervous and anxious about being selfish because he repeats this a lot. This is one of these fixations that she's reported. But as far as how he presents to her, the outsider, selfless. Selfless when it comes to his wife and family. We skip forward now to December the 6th, at which time, this is after, after he's gone back into remission, I guess, and he's still been in prison for a while. December 6th, that he was an innocent man, I think actually we're backpedaling. So we're backpedaling now. This is, we went forward and now we went back. So before he has this big breakdown, he's saying he was an innocent man and he felt like he had already been convicted. This answer got out. The state objected and asked for them to have a sidebar. And the judge came back and said that it was sustained, but there was no motion to strike the statement. So it's out. The jury has heard it. It's going to be in. We figured out later on, because she repeats it, that the nature of the objection is that the defendant cannot introduce his own statements for the truth of the matter asserted. This is that, I've talked about this before, the self-serving hearsay kind of idea. Admissions of a party opponent are exceptions to the hearsay rule. So if you're in a lawsuit and the other guy says something that incriminates himself, you get to use that against him. But if he also says something that is exculpatory, he doesn't get to use that to defend himself, because as to him, it's hearsay. He's not his own party opponent, so it doesn't fall within that particular exception. The only real exception to that you can sometimes get some workaround with is a lot of jurisdictions, they will have a rule of completeness is the idea. And it's just basically saying, it's recognizing the risk that isolated statements that are cherry-picked, they can be misleading. And so even if other statements would technically be hearsay, if they are necessary to place the statement reasonably in context and make sure that its meaning is not misleading, then in that situation you can sometimes introduce some of those surrounding statements. My argument here would be, it's not offered for the truth of the matter asserted. It's offered for his state of mind. It's up for the jury to decide if he is factually innocent, but the fact that he thinks so, that's kind of relevant to what we're talking about here, because it goes to why he's doing all these confessions, and therefore whether they are believable, whether they are credible, whether there's something that the jury should give any weight. December 29th, he was expressing other frustrations. He was unable to get a regular toothbrush from the commissary. He wasn't having face-to-face visits with his wife. He was sleeping on the floor. He had no TV. He felt that he was being treated worse than those who were convicted of their crimes. On January the 17th of 2023, he was talked about his cell conditions. He said he hadn't received a letter from his wife and it was missing a page. And he had severe heartburn. At this point, the judge calls them up. Let's have a sidebar. I don't really know why. It didn't seem to change anything. We came back and continued to talk about this note. He complained about ants and rodents in his cell, and she confirmed that she also got those complaints from other inmates. Ants and rodents in the cells. Just in case we hadn't heard enough about how gross this place is, they got ants and rats in there. Like, that isn't he's here for his safety, and let's put him in with like a major health hazard. He asked if he's like they're tearing this prison down, aren't they? And the state objected to that as to whether she knew that, her knowledge, and it got overruled. And he just confirmed, yes, and they're building a new prison next to it. So this place is so bad. That's probably part of the reason why they are doing the rebuild. Get rid of the rats and the ants. On April 4th of 2023, asked if she observed clinical risk factors. This is right as he is engaging in that confessing activity, right? Are there clinical risk factors at this time? There's recent suicidal ideation. There's fatalistic delusions and fantasies, hopelessness. He's giving his belongings away. He's in intense turmoil, despair, hostility. There is so much more that she runs through in this list of risk factors that she's observing right as he's confessing. I couldn't even write them all down. I couldn't catch them all. He's giving his things away. That's preparatory stuff. This is not light. This is starting to be preparatory. This is moving out of ideation and starting to go towards taking action. That's important context. It just shows he's in a desperate state. He's in a desperate state. He wants out. April 13th of 2023 is a finding of grave disability. And that is an important finding, as we talked about, because that's where the state then has options to be able to give you psychiatric treatment against your will. The grave disability is when you are unable to take care of your activities of daily living. So this is the washing, the bathing, the feeding, all of that type of stuff, transferring, moving from one place to another. On April 13th, okay, right after this has started and right when we're in the midst of this really, really bizarre behavior, the feces eating and so forth. So in this particular instance, what that triggered was the option to administer psychotropic medication to him involuntarily. And so what that means is they gave him a big old shot of Haldol. On April 20th, it was reported that his cognitive issues had worsened after, presumably, getting the shot. His cognitive issues had worsened. On May 11th of 2023, she reported that he was showing preoccupations and paranoia. Don't know what the preoccupations were. This could be the head banging against the cell. We could look back at the day yesterday and see if that's the time frame from when that when those guards were reporting that type of behavior. The preoccupations makes me think it's something like that behavioral and not that he's just like stuck on an idea or something, because I think they usually call that perseveration. If it was just like he's obsessed with talking about something or he's saying the same thing over and over again, I would think that would be perseveration. So preoccupation seems like he's obsessed with doing something. And that's consistent with that head banging activity we heard about. Banging his head against the wall. Banging his head against the door until he gives himself injuries. On May 18th, 2023, he received his second injection. And confirmed at this point, yeah, this is Haldol. This is Haldol. Very serious antipsychotic medication. It can be very effective. Dosage can matter a lot. It can have, different effects on people depending on what the dosage is. People will react to it differently. It can also have some very serious side effects. And some of those can be permanent. Some of the effects of Haldol can be permanent. Really important to know that when we're thinking about how Rick got treated. And in context of questions like, is he going to testify? Is he going to testify? Big question about that. Is he able to? Is he able to at this point? The Haldol shots are supposed to last about 30 days. So that would tell us, hypothetically moving back, okay, sometime between the 13th when they approved getting the psychotropic meds And the 20th, when he was having those cognitive issues, is when he got the first Haldol shot. So looking forward then, that would theoretically extend into June. She said she didn't really know if he got them for very long. She didn't think he had gotten them for very long. So she didn't know if he was still getting them in June. May 26th, she observed 2 black eyes, and she attributed these to self-harming. Now we definitely know he's hitting his head against the wall to the point that he got 2 black eyes. She does not know if the Haldol shots were not working, because she has nothing to do with the medications. She doesn't know anything about it unless he told her or someone reported it. She's a treating psychologist, and she doesn't know about his meds. She doesn't know about his meds. There's apparently like no integration of care with the psychiatrist. That's alarming. Like, that's got to be contrary to good practice. On June 5th, he received another involuntary injection the day before due to his self-harm, the head banging. So apparently it doesn't seem to be working. He's still doing it. This one is an emergent injection, meaning she described it as it doesn't fall under the other shot. It's a different one. So now he's getting a different drug. He's already been pumped full of a month's worth of Haldol, but it's not working. So he gets another shot. He gets a different shot, and that's to stop him from the head banging. On July the 26th, she reports a physical condition. His eyes are bulging out of his head. Did not think this could be attributed to depression. No, I would sure as hell think not. I would think not. I would think that's a pretty atypical symptom of depression. Kind of sounds like it might be a symptom of medication, though. But she didn't have a medical explanation for why his eyes were bulging out of his head. But fortunately, by August 16th, there's a change noted that his eyes are no longer protruding out of his head as they had been for at least 4 months now. 4 months? April? Haldol? Timing fits. If anybody in the chat knows if that's like a potential side effect of Haldol, I mean, it can have very serious physical effects. The one that everybody knows about, the one that's commonly known about is the tardive dyskinesia. And what this is it basically just creates, it looks like Parkinson's when you have a tremor. It creates a repetitive movement. Sometimes it's like, a mouth movement. Something like that, a very repetitive movement that they can't stop. And this is permanent. These are permanent effects from Haldol. Obviously, not everybody gets them, but a lot do. The incidence can be pretty high, especially the longer that you are on a medication like that. November 8th of 2022, we just note there's a piece of information. There's a note from his medical file. This is from his intake, and it notes his height, 5'5", and his weight, 173.8. So we have that to kind of visualize his stature at this particular point in time. 5'5", my standpoint, I'm a 5'10" woman, a short man. Definitely shorter than the eyewitnesses who were out on the trail, who said they were 5'7" and reported that the man that they saw, that they identified as Bridge Guy, was significantly taller than them. Definitely don't sound like Rick at that point. Had our afternoon recess at that point, and a little pause. And when we come back, I just made this little note because I just noticed it. Mr. Rosie was, he was in the groove, you know, he was comfortable. He was very prepared. He knew where they were. He knew they were going, and he stops. He comes back and he says, "All right, Ms. Walla." I also noted he called her Ms. I might take issue with that. She is a doctor. She is Dr. Walla. Called her Ms. Walla. Maybe it was intentional. I don't know. I think it was maybe just a slip. He refers her back to these references about meeting with the attorneys being when his behavior changed. That it was after he met with his attorneys and after receiving the discovery. Now, she acknowledges that she never saw his discovery. She doesn't know what they had told him. She knows that their sessions, their meetings with him were videotaped, and he asked her, "Did you ever watch them?" Ooh. He was trying to get a concession there. If anybody watched videotapes recordings of a man consulting with his attorney, they got a big problem. That is a big problem with the case. That is a major interference with your right to counsel. Don't know how they'll handle it in Indiana, my state. It's probably getting dismissed. I mean, we had cases, including some serious cases. Like I think, if I remember correctly, there was a murder case. There were some serious cases because the jail was improperly recording attorney-client phone calls, and then they were going back and listening to them, and so a lot of problems got caused by that. You don't get to do that. It is confidential. Of all the things that they should cover in their training, their policies, don't violate attorney-client privilege. It really needs to be up there. But I've talked about that battle that I've had to fight. It seems to be just a constant 2 steps forward, 1 step back when you're dealing with being an attorney in a prison facility and trying to get any sort of respect for your job and your role and the importance of confidentiality to that. She agreed that any conclusions that she would draw about the impact on him from seeing the discovery, what was in the discovery, and the meetings that they had is speculative. That would be speculative. Yeah. I mean, we could talk about trauma. I mean, don't let anybody tell you that seeing this stuff can't be traumatic. It can be traumatic. It's not going to be for everybody, but it definitely can be. It definitely can be for some people. If you're not desensitized to it, it can be very, very difficult to see a crime scene like we saw. And a lot of the photos that we saw, that's going to be in his discovery. I can see that causing you nightmares. Easily. The first time I remember seeing crime photos like that, sort of like that, was actually it was a long time ago. It was when I was in high school, and it was because I saw the Manson scene. The photo of Sharon Tate on the couch, very dead. And that stuck with me for a long time. I didn't have nightmares. Never had nightmares about it, but I remembered that. I mean, to this day, I can see that image in my head. When they would meet at the cell door, she would take notes standing there. She acknowledged there was a huge backlog in treatment. I think it was medical treatment or psychiatric treatment during Mr. Allen's stay. I think it was medical. And so Dr. Martin, the psychiatrist, he had come over from ISP, which I don't know what that stands for, but it's another one of the prison facilities, in order to reduce the backlog of offenders waiting for treatment. On rounds, she might see 50 to 60 inmates per day. She's seeing a lot of people while she's running around taking these notes on her paper. At some point, she would reduce her notes into typed form, and then she would destroy the notes. And Mr. Rosie says, "Isn't it true that is a violation of APA guidelines?" She says, "Well, I wasn't sure that it was a violation of APA guidelines, and so I asked, and nobody knew." And Now, remember, we're at the point where your deposition, remember your deposition. We talked about this at your deposition. Do you remember? Being asked? The guideline is that if litigation is occurring, that you should retain them. And she just says, if you say so. She's not going to fight him anymore. If you say so. That's what happened at the deposition. Ms. Diener objects at this point because she's nitpicking the deposition, and how in the deposition the APA guidelines are apparently several pages, and Mr. Rosie had gone in and highlighted the pertinent part and showed her that, and therefore she hadn't read the entire policy, and so her understanding wouldn't be contextual. That objection was also sustained. But there was no motion to strike, so the jury heard what they heard, and he moved on from there. And either way, she acknowledged that the best practice was to retain the notes, and that the best evidence of what Rick Allen actually said would have been those handwritten notes, but we don't have it. So just more of those seeds that the defense is planting about the things that weren't done, the things that were lost, the decisions that were made, that the jury could have had that information, but because of these calls, that's not happening. Major depressive order. She agreed that you could move in and out of that in stages. She described that as waxing and waning. So kind of like you can have lucidity with psychosis, you can have waxing and waning of major depressive disorders. External factors can affect your symptoms. It could be phone calls. It could be an inmate comment. It could be fighting with ants over your food. Mr. Rosie is great with these examples, when he wants to say the same thing over and over again and really highlight the details. Fighting with ants over food. That was a pretty quite a visual there. We acknowledge that serious mental illness is defined in DOC policy. So we heard yesterday from the guard, who I think was one of the Odin patch guards. I didn't have a chance to go back and verify that, but the name, I'm pretty sure that the name was one of the Odin patch guards. He had his own definition of serious mental illness. He testified, they have theirs, I have mine, and mine is when because of someone's brain, something's wrong with someone's brain. They're acting up. We didn't actually get the definition of serious mental illness from Department of Corrections policy, but we did get a concession that Mr. Allen fit that definition. And it wasn't like automatically just because he had this major depressive disorder diagnosis, but because that was in conjunction with functional impairment. So those two things meant that he has a serious mental illness as defined in Department of Correction policy. Well, here's a big boom. Here's why the civil lawsuit is coming, whether he gets convicted or not. Under Department of Corrections policy, you are not supposed to keep seriously mental ill individuals in solitary for more than 30 days. And that's based on a recognition that long-term solitary confinement is detrimental to mental health. Very well understood and known. And despite that, Rick Allen was in solitary for 13 months. 26 times the permissible length. No, 13 times. Sorry, got that backwards. 13 times the permissible length under the policy, because even 30 days is going to be a long time in the hole. Like you could easily deteriorate in 30 days in the hole, especially if you're fragile. But more than that, very, very serious risks to long-term mental health and well-being. And he was in for 13 times that. She agreed it would be reasonable to believe that environment, those conditions could have negatively impacted his mental health. Yeah, I think so. I think there's quite a bit of evidence of that at this point that we've just heard. She agreed that she would never use solitary confinement to treat Mr. Allen, but that's how he was treated. In the notes, it was reported that the psychotic processes that he was experiencing occurred during March, April, May, and June. So she had limited it to that basically April to May period, and gotten that brief psychotic episode diagnosis. But now this is contradictory to that, because if he's at least if he's showing the processes sufficient to meet the criteria, 4 months. 4 months is more than 1 month. So he wouldn't meet the brief. He wouldn't meet the brief psychotic episode criteria. He would have some other condition. She agreed that there was an abrupt onset of psychotic processes and behavior in early March. So well before the confession activity started, they were aware he's starting to display psychotic behaviors. Now we visited the faking behaviors, and while Dr. Walla was questioning the genuineness of the behaviors at the time, now she is unsure whether that is the case. She has changed her mind. Changed her mind whether that is the case, and she agreed that is with the benefit of hindsight. With hindsight, yeah, maybe this all was real. Maybe he wasn't faking it. Unbelievable. Their one job was his safety. Their one job was to keep him safe. And they destroyed his mind. And then accused him of faking it. Almost like it would, I don't know, serve some secondary gain on the part of the Department of Corrections if he was just faking it and not really mentally ill. Think that would serve some secondary gain? You know, when you sue a facility for violating your rights, violating their policies, engaging in activity that, from my understanding, from what we heard at the pretrial hearing, has already been held to be an Eighth Amendment violation in a federal court in Indiana. Part of the reason why all these policies had to be modified, long-term solitary confinement. You already know that this is a problem. That can be an issue for qualified immunity, potentially. Could be an issue. Not a district court decision in and of itself. Beauty of qualified immunity is all the outs that the police officers have. If the appellate courts have not specifically held that the exact set of circumstances that you're arguing is a violation of your rights has come up before in that circuit and be found to be unconstitutional, then you can't get past qualified immunity, meaning you can't sue anybody individually. Can't sue anybody individually. They'll all get away with it. Answers part of the question about how things get the way they get that we talked about last night in that extremely long stream. Yeah, a little secondary gain because damages matter. Damages matter. And if you're just faking mental illness, you don't have any damages. But if they seriously damaged your mental health, yeah, you might be getting a lot of compensation for that, whether he's convicted or not, because you don't lose your right to be free from inhumane treatment when you're convicted of a crime, because the whole point of our criminal justice system is we are supposed to be better than the people that we are punishing. That's our standard. So when we fail that standard, yeah, he can recover for that. because we're being no better than he is at that point. So taxpayers, think about that. Think about that. Stacy Diener had a redirect where she first established that as opposed to Dr. Martin, they were separate providers. He was the one who prescribes the psychotropics. She's the one who provides the therapeutic services. I put that in irony quotes because they don't seem to have been particularly therapeutic for Mr. Allen. That the backlog in medical services was unrelated to her services that she provided. And this is just going to the notes process. The defense was kind of, I think, implying that her notes may have been inaccurate because she would have been in a rush. She had a lot to do, taking all of these notes for these different visits, going back, and that's why they would have been the best evidence. So she would take a piece of paper, she would take her notes, she would then go back to the office and put them in, and she would shred the notes. And part of the reason, so to start off, as far as rounds versus sessions, because that had come up as a distinction, the rounds, she could be seeing, 50 to 60 people at a time. Well, those are different things. Rounds and sessions are different things. We didn't get an explanation of exactly how they're different. But she said that Mr. Allen was not on rounds. So it wouldn't have been, he was in the 50 to 60 people that she was trying to see, all in one day. The cubicle sessions could be 15 minutes, 30 minutes, 1 hour. There was no real limit on the time. They were confidential. And she said there was no reason to think that the notes were entered incorrectly. That was always her practice. And the reason why is because the paper notes aren't secure. I thought this was actually a pretty decent point. That's a pretty decent point. With Rick Allen, there was increased concern that the paper notes could be disclosed. And that was the reason why they deviated from the ABA guidelines, which she said before she wasn't sure that it was a violation. Now she seems to be conceding it is, but they deviated from it for a purpose because it was for Rick Allen's safety. Even though apparently it seems like the entire prison already knew. Like from very early on. It was in November that they were calling a baby killer and all that kind of stuff. They already knew who he was, what he was there for. As far as her true crime habit, she now says, remember she said, yes, they had a conversation. They had a conversation about it. Then she gets confronted with her deposition where she said they never discussed it. Now we're going to talk about it again. We're going to get like a third version. So she now reports that there was a conversation with colleagues and supervisors in November of 2022 about taking him on. The conversation was with people she identified as Deborah Karras and Dr. Burden, which is B-E-R, Dr. Burden. They are employees of Centurion. And this was at the time because they knew that he was coming in, but they didn't necessarily know where he was going to land, like which facility he was going to land in. So she knew that he was going to be arriving on suicide watch, and she doesn't remember anything extensive about the conversation. And she was asked, did you disclose your interest in true crime? She said they were aware. Well, that's a little bit avoiding the question, isn't it? They knew that she was a fan of true crime, that she covered, that topic was covered with her supervisors, and they did not express any concerns about that. And that she made them aware that she followed the case. And she was able to separate the interest that she had in the case with the interest she had in his treatment. And we're just to take her word for that. Even though, well, Mr. Rosie got this bomb in, so I'll let him have that credit. She's able to keep her personal interests separate from the treatment, and that she treated him as best as she could. She was asked about sharing podcast information and asked why. And she said that she told him that he had supporters in order to help him maintain hope. People out there believe in you. you know, probably is a good thing for him to know, but really not her place. Really not her place to be telling him that. As far as the stressors, they talked about the cell conditions and the yelling from the inmates. Those complaints were more common when he first got there and was adjusting during November, December, January timeframe. But eventually he adjusted. She was sure that there were things that he wanted after that, but he was mostly interested in just getting the visits, the family visits. Once again, the family coming to the fore here. And that when he began confessing, there was no other change to his circumstances besides receiving the discovery and getting the attorney visits. I don't know why they think this is like a dunk. This is not, I don't see this landing for the state. I mean, again, yeah, it makes sense to me. You're already fragile and you're upset and you're not sure if you're going to be stuck here for the rest of your life, and people are yelling and screaming at you, and you can't have visits with your wife. And your life is just in complete and total disarray, and you don't know what people think about you. And maybe you're even starting to question yourself and your own sanity. And maybe if everybody else thinks this about me, maybe they're right. And then you get a packet of discovery with some of the most gruesome photos you have ever seen in your entire life. Maybe something that you've never seen anything like that before. Brutally murdered young girls. Yeah, that might tip you over the edge. I don't know why the state would highlight this. She revisited how in his intake info, he had reported no history of sexual abuse, no history of alcohol abuse. And then he changed those reports later on, where he said he had been alcoholic twice in 2011, which, now I'm just starting to wonder if this is just one of the incoherent things that he said. I was trying to make sense out of it. Maybe I heard it wrong. Maybe he was talking about going into treatment. Maybe he was talking about being hospitalized. But maybe he just said he was alcoholic twice in 2011 because he wasn't making sense at the time. He said an awful lot of nonsensical things. Anyway, also had not initially reported being a sex addict, which he said later on in his confessions. And she elicits that people underreport in unfavorable areas. So if you think it's going to make you look bad, you'll tend to underreport it. That is true. That is true. Mr. Rosie says you don't know if he was underreporting alcoholism or sex history, and he was telling you all kinds of things during this time frame that were untrue. Mr. Rosie was definitely testifying in this recross. He was getting away with it. As far as being able to separate her personal interest from her professional interest, in fact, she went to work and searched for info in the database directly related to this case for her own personal reasons. And in fact, got her fired. Had to do a whole investigation. Yeah, that doesn't seem like a very good separation of personal and treatment to me. Doesn't seem to be like a very good separation. Acknowledged that they had discussions about the case. And she says, there's always that interest. Yeah, there is, which is why it's not appropriate for you to be his treating therapist, because you always have that interest. But she wanted to because she had that interest. And so then you just have to wonder how much you can trust what she perceived and what she reported. How objective is she really? She's got her opinions about things. She's looking to confirm them. That's what people do. That's what humans do. The confirmation bias. She's testing her theory about who Mr. Allen is, and everything that she is seeing is going to be filtered through that. That's why you're not supposed to be his therapist, because that interest is always there. The sessions, we reiterated, the sessions in the cage would last somewhere from 15 minutes to an hour. She would be watching and making an assessment during that time. And now we note that there is a way to objectively test people for feigning. These are those malingering measures that I talked about earlier. And that they don't have those materials. But when asked, might you defer to someone who did? She doesn't know. Doesn't know if she would refer to somebody who used a highly accepted, widely used, validated instrument for detecting malingering over her own, whatever she relied on to come up with the thought that he might be feigning, but maybe she's not so sure about that now today. She agreed that the reason for destroying the notes was to help him maintain his privacy, but yes, he has a camera on him the whole time. There were posted inmates at the door. There were guards posted at the door. He didn't actually have any privacy. And we already know the information got out. So now, okay, we've heard the story the first time. Disclosed the interest in the case before she was assigned. Then we heard in the deposition she didn't. Then we heard this last time. Well, they had a conversation about true crime and they all knew about her interest in true crime. So Mr. Rosie gets right to the point. Did you talk to staff members about your interest in this case? And she has to concede, no, she did not bring up this specific case. When they were talking about her interest in true crime, she never actually disclosed to them that she was following it. She was talking online about it. And as she concedes in the final question of this examination, yeah, she went to the Monon High Bridge. She visited the crime scene. And her explanation was, well, it was on the way. She was going somewhere and it was on the way. The High Bridge Trail is not on the way to anything. You do have to leave the main road. You have to go there deliberately. You don't just accidentally stumble upon it on your way to somewhere else. Really, the minimizing. She's really, really minimizing this because she knows. She's very, very defensive. She knows how bad this is and that her credibility is shot. You can't rely on her objectivity in a position where her objectivity is critical. The jury had questions. Again, good questions. May a diagnosis of brief psychotic disorder return after behavior is returned to normal? The answer was, it's possible. Is it expected or normal for brief psychotic disorder to recur repeatedly? She said that was also possible and that it could also be an issue if you had major depressive disorder with psychotic features, which I wonder if that might be one of the alternative diagnoses that we will be hearing from a defense expert. Would Richard Allen know the difference between 3-meal refusal and 4-meal refusal and the consequences of that? They're really questioning her. She says she discussed it with him. And Rosie follows up on this, that meal strikes, like hunger strikes, they are the most common form of protest in the prison because it is the only means of control that the inmate has. It's the only thing they can control is refusing their food. That's why it's so common. You hear about it a lot when they're upset about something. Yeah, hunger strike. It's the only thing you can do because everything else, you're in the panopticon. He is literally in the panopticon 24/7, being monitored. All of the rules he has to follow. He resists in the tiniest way, he will get tased. I can understand that. What is the relevance to grave disability that indicates use of involuntary injection? So she testified that it is one of the prongs. Diener follows up. It's one potential prong of many factors, and she agreed, yes, and there are others. As far as Richard Allen, he got it for the other reasons, which is strange because it's not what she testified before. The grave disability was what precipitated the finding that he now met the criteria for the involuntary administration. But now she says he got it for other reasons. He got it for harm to self, harm to property. And okay, so maybe it's just in addition to, and he's also unable to take care of his activities of daily living. That is the grave disability. So yeah, other reasons as well. Once they do a hearing, he is on the regimen. So once they have the hearing to determine that he meets the criteria and that conclusion has been made, yes, he does. He can be injected involuntarily. Then he is on that regimen until the psychiatrist decides to continue it. So now you are at the mercy of the psychiatrist who is injecting foreign substances in your body that may or may not be causing your eyes to bulge all the way out of your head. So maybe you might refuse a meal once in a while. Did Mr. Allen come to Westville on medications? She said he did come on them. They were tweaked. When asked what one, she said it was Prozac. She didn't necessarily know if somebody was taking their medications. She acknowledged that. She said that they were tweaked after he came and asked what that meant. She said she thought it meant as to dosage. His dosage was tweaked. She had mentioned Seroquel earlier in the testimony. Would have liked to have followed up on that. Where does that come up? Because I don't think that one is typically prescribed for just depression. Seroquel is I see that very common with bipolar disorder. But I think, a lot of what happens with a lot of these illnesses is it's a little bit of a hit or miss. You try something, you see if it works. If it doesn't work, you try something else. And it can just depend because people manifest in so many different ways. And he, from everything that we heard described, like particularly the 9 days without sleep, that sounds like mania. That sounds like a manic state. And so it could be if he had mania associated with his depression at any point in time, maybe he would have gotten Seroquel for part of that. I don't know. But the Seroquel was never explained. She didn't follow up on that. Do you screen for delirium as part of your mental status exam? Oh, somebody knows how to do a mental status exam. Somebody knows what that means. Do you screen for delirium? No, not until something comes up. Not until something comes up. They do not screen for delirium. When was Richard Allen diagnosed with depression and anxiety? Her answer to this is when he arrived at DOC. And that is completely inconsistent with what she testified to previously. That he came to DOC already having those, already being on medication, that he had been in a clinic. He'd been in some kind of outpatient clinic for his treatment. I'm not really sure, not really super sure how these things get reconciled. And I'm going to just try to flip back to the early part across where they talked about this. He had the code. When he came in, the code D. She said on cross that he had a major depressive disorder diagnosis when he landed at DOC, and it was part of his psychiatric history. She's given a different answer now. She recalled noting depression, anxiety. He was taking meds, knew he visited an outpatient clinic. Now she says he didn't get the diagnosis until he landed at DOC. And Mr. Rosie elicited that it was that, she understood that actually, regardless, he had struggled with it his entire life. She did not fight that. Does DOC require complete medical records, or are they all self-reporting? She says they often don't have outside records. So this is the kind of question that it could go a couple different ways. This could be a concern about, is the information you have about Mr. Allen reliable? Like, could he just make stuff up? Maybe he did that here. Maybe that's part of the faking. It could be a question like that. But it could also be like, how crappy is your psychiatric treatment at this hospital? Like, do you do anything to verify, to get like some kind of a valid, historical information, some patient history, in order to make the decisions about how you treat people and house people and all that stuff? Really could go both ways with that question. I like how it's worded because of that. It seems clever to me to not really have a major tell one way or the other. Often they don't have outside records. However, Rick had signed a medical release, and she had, in fact, seen some medical records in his chart. So good little point there to just emphasize that if they didn't have his records, it wasn't his fault because he had given them the release. So not hiding stuff back in his record. We took our recess then, our afternoon recess, and when we came back, we were told that the state now has 2 short witnesses and 1 lengthy witness. We would be taking that lengthy witness up tomorrow. So based on that, we are pretty sure that we're going to be done tomorrow with the state. The state is going to rest, and we'll start to get into the defense case. There will be a halftime motion here. I don't know what their specific verbiage is in Indiana, but pretty much every state has this. After the state rests, there's an option to make a motion, and sometimes it's a directed verdict, sometimes it's judgment as a matter of law, sometimes it's dismiss. That essentially the state hasn't met its burden of proof, that the evidence is insufficient to prove the charges beyond a reasonable doubt. They're absolutely going to make that motion just because the case is so weak. The case is so weak. They're going to point to the lack of identification. The fact that he doesn't fit the description of bridge guy. There's no verification that he was, on the trail at the time he said he was on the trail. The car might not be his car. There's no real way to confirm that. The bullet might not be his bullet. Couldn't exclude the other guns, from making that bullet. And these confessions are unreliable. They're just going to basically say like it's all bad. So you should make this finding. It won't win. It never wins. Like almost never. The only time it really wins is if they literally like forget about a specific element of the charge, and they just forget to put on evidence about that. Then sometimes you can win. You can win on a directed motion, a directed verdict. So I had this once. It came up. It works well with like some of these maybe technical, maybe regulatory types of crimes, things like that can get a little bit complicated, and maybe they have lots of elements and stuff. So in Washington, the statute for eluding a police officer, you don't stop. They turn on their lights and whatever, and you don't stop. It has all kinds of different elements to it, tons of different elements. And one of them, there are things like the police officer has to be in uniform. It has to be in a patrol car that is equipped with lights and sirens, and it has to be a visible indicator to stop. And that, based on that, the individual, refuses to stop. And I think there might be some element in it about like engages in reckless, like the behavior is reckless or something like that. So in this particular case, it just happened that they completely forgot that they needed to show that the patrol car was marked, that this was a marked, or no, it was either that one or that the police officer was in uniform. There was just no evidence of it at all. And this happened multiple times because I knew that because the prosecutor was trying to argue, well, but circumstantially you can infer it. No, somebody made that argument several years ago and it already went up to the Court of Appeals and they said, nope, you can't infer this one from these types of circumstances. Basically the same thing that the state was saying. So those types of situations, sometimes you can win a halftime motion, but overwhelming amount of the time you're not doing it. It's not going to happen. Maybe they'll forego it. I just don't think they will because it is such a weak case. And part of the reason to do that is for the argument. It's for the argument. It's part of the public process. It's there in the record. You're getting a little bit of a rehearsal, a dress rehearsal of your closing statement, your closing argument when you're gonna go in and blast how weak the state's case is. So it's like a test run, and I expect them to do it. But after that, we will be moving on to the defense case. And I will tell you, let's get through these last two witnesses that were very short because I'm now really intrigued about this defense case. Steve Mullen came up to the stand again. So remember the jury had that question about, didn't it ever occur to you to go and research how many 2016 Ford Focuses are registered in Carroll County? And he said no. Well, now 6 years, 7 years later, and nearly at the end of the state's case in chief at trial, they decided to go ahead and do that. So he testified that he believed the vehicle matched Rick's 2016 Ford Focus SE. So he went and did a DMV search to follow up. And so he searched for black 2016 Ford Focus SEs as of February 7th, 2017, registered in Carroll County and surrounding counties. He didn't specify which surrounding counties, just surrounding counties. Introduced that. It's Exhibit 305. And there are 31 entries on that spreadsheet. Now, he clarified that the spreadsheet covers a period of 2016 to 2017. So there are duplicates on the sheet. And if you take out the duplicates, it leaves you with 18 in Carroll County and the surrounding areas. Now, that's not a small amount. And on a really nice day when everybody's out and about and going to this trail, does not seem highly improbable to me that one of those other Ford Focuses, other 2016 Ford Focuses, would have gone by on that road. So now they testify that they took out everything except the black Ford Focus SE, because that's what Rick had. And I was really confused about this reasoning because it sounds like you're just saying, like, you don't know what you can't eliminate everything but the 2016 black SE from the camera. Like, you're literally just trying to do something that would eliminate everything but Rick's car. I guess it just came across as very misleading. So anyway, if they only look at black Ford Focus SEs from 2016, there are 8 of those, and only one of them was in Carroll County, and that one belonged to Richard Allen. Ms. Auger cross-examined, of course, the simple point, people from other counties can visit the trail. People from all over the world can visit the trail. And you can't tell from the Hoosier Harvest Store video what model the car is. It has, he referred to it as the Ford Focus SE. There's a Ford Focus SE, Ford Focus Titanium, and Ford Focus S. And so she also elaborated that there are at least 5 other years that have similar body types from 2011, from 2017. And you can't tell which one of those it is on the camera. So he did, in fact, do another spreadsheet that would include all of those other ones. And that if you look at that spreadsheet, you have another 65 Ford Focuses. He says he's not sure how many. And she says, well, you could have counted them. Yeah, he could have. And she says, and you could have admitted that list. The bigger list, you could have put that into evidence for the jury. They are calling out these guys on the misleading and the manipulation of the evidence. She's really calling them out on it. You could have put this comprehensive thing that this car could be, you could have put that in evidence, and then they would know 65 more. 65 more. That is a lot of possible cars that could be going by on that road. At this point, he answered that the prosecutor could have. You could have admitted that list. One, the prosecutor could have. The passing the buck theme, it just continues. It continues to the final conclusion of the state's case. All of the mistakes are somebody else's problem, whether it's the clerk, whether it's the dispatcher, whether it's the prosecutor. If this case crashes and burns and ends up in an acquittal of Mr. Allen, who's Mr. McClellan going to point the finger at? Oh, this would be a show, to be a fly on the wall when the recriminations start about whose fault it is for blowing the case. They didn't have a case to blow in the first place. Mr. McClelland had an objection that, well, wait, not yet. So he says, of the number of the other list, what was the number in Carroll County? I didn't get that number. Which ones were specific to Carroll County? Or he may not have. He just said like a number of them are registered in Carroll County. Well, yeah. And he just reiterated, you believe the car on the store video matches Richard Allen's. Yeah, we know that's his opinion. We're trying to get into the basis of his opinion and not taking his word for it. And all they have is this default to just take our word for it. You believe it. This investigator, he thinks it, the one that Rick Allen walking down to the interview called an asshole, and everybody in the room laughed. I'm like, yeah, he really was an asshole in that video. We're supposed to rely on his belief. They're getting desperate. This was really desperate. He was very deflated at the end of this question. Like, he knew. You knew you tried to set that up to be tricky, and you got called out. Maybe if you don't try to be tricky and manipulative and distort things and misleading, then you won't get called out for it. Just a thought. Jennifer Auger, recross. You can't see the plates. You can't see the model. You can't see it if it says titanium or S or SE. You can't see any of those things on the car, on the video. And there's at least 76 other black Ford Focus or in similar body type cars in Carroll County and surrounding areas. This is the point where Mr. McClelland jumps up and objects. I object. That's not an accurate representation of what the document says. And if we have a sidebar, I can explain. This objection is sustained, which is odd because, there's nothing pending now. Like, it's done. It's done. It's in. You didn't move to strike. The evidence is in. They're going to see the spreadsheets for themselves. And these jurors are so much smarter than Investigator Mullen. They're going to figure it out for themselves. They're definitely not taking his word for it. They're going to figure it out for themselves. But it was just that irony, that the darvoing of you literally just got up there and tried to be tricky, and now you're going to get all clutching your pearls because you think the defense is being tricky. We see you, Mr. McClelland. We see you. Jury question. Oh, this one was devastating. If you know, are the rims wheels on his Ford Focus specific to his make, model, and year? And the witness had to answer that the SE version includes the rim selection that is on Rick's vehicle. And he doesn't actually know if it's available in other models or other years. Yeah, it's the sport package. It's the sport package for the Ford Focus. I went and looked it up because I see this wheel. I see the photograph of the car in the garage and I see this wheel and I'm like, that's not a custom wheel. It's maybe not like the lowest end wheel, but it's not a custom wheel. Like custom wheels, you can spot them. They're fancy. They stand out. They're very distinctive. This is just a very standard. I suspected it was part of a package, and yes, it is. It's an upgrade. It's an upgrade for this car. The jury did send up, I noticed this time they did send up a second question here, and that second question was not asked. We only got the one about the rims. Okay, boy, then the drama of the day. Like if the whole like true crime psychologist wasn't enough drama, then we got Brad Weber on the stand. Now, I don't want to be rude. I really don't, but I also want to be descriptive and I want to be able to characterize things in a way that people can get a clear image of what was happening and the effect of it. And so when Mr. Weber walked into the courtroom, the parenthetical note that I made was deliverance. Mr. Weber, he looked like he could have been in Deliverance. Like he literally looked like some of the main characters in Deliverance, like, you know, in all the bad scenes that everybody knows about. He looks like that. And he behaves like that. He comes kind of slouching in and sits on the stand, and he's very uncomfortable. He spends most of the time with his chair turned so that his back is entirely to the jury. And he is working his mouth the whole time on the stand. I know a lot of the side stories about this case and some of the side theories and the possible other things that are involved and so on and so forth. And I don't really take any position on any of that because I'm focusing on what's happening in the courtroom and what's, you know, the evidence that comes out in the courtroom. But I just have to tell you, I've seen meth mouth an awful lot. Seen me an awful lot of meth mouth. Sure is what it looked like to me. So Mr. Weber was a character, like right from the moment that he got on the stand. We knew already he lives at the end of the private drive that goes under the Monon High Bridge Trail. In February 2017, he worked at Subaru, and his shift would run from 6 to 2:30. He provided the address of where Subaru is. The state introduced his timesheet for February 13th of 2017. And that showed that he clocked in at 5:41 that day and clocked out at 2:02 p.m. He then testified that he went home and that the drive home takes about 20 to 25 minutes. And the state then introduced Exhibit 311, which is a photo of a white Ford Econovan. And he identified it as his. He had it in February 13th of 2017, and that's what he drove to work and home. This is the state's last hope, the white van. The white van is the distinctive detail that Mr. Allen provided in his confession to Ms. Walla, to Dr. Walla, that we haven't heard about before at trial, and that it's something that I don't think is publicly known. You know, I don't think that was really publicly known as part of the investigation. Certainly not at that time. I mean, a lot of things have become publicly known since the cases has become public, and so much of the material has come out through the pleadings and the hearings and stuff like that. Now, of course, it could have still been in the discovery. We can't rule that out. But the state is going to try to use this as their corroboration of this is the story. This is the missing piece. Rick Allen said, you know, when Mr. McLeland gave his opening statement and described the crime, he used what Mr. Allen said in this confession, that he wanted to have his way with the girls, but something happened that interrupted him. He got scared, and so he just killed them instead. Put the the branches on them to try to hide them. And then he left and went home, and you never heard anything about him again until 5 years later. So, I heard that confession, and my first, like I said, my first reaction when we get through the direct examination with the state is, wow, this could be pretty damaging. Like, this doesn't sound good. This sounds very detailed. That sounds like something that can be verified. Maybe he did. Maybe he did. Then we got the major impeachment of Dr. Walla, and the fact that he had, already had his discovery when he's making these statements. And she's talking to him about what everybody is talking about on the podcast and stuff. Like, okay, maybe it's not so strong, but still, like, I'm more skeptical than the average person. I accept that. I definitely accept that. I'm happy to entertain alternative theories of things. There's no guarantee that the jury is, that the jurors are going to share that kind of mindset. So I'm like, this is really not looking great. Really not looking great for Mr. Allen with this particular confession. And so this Ford, this is going to be a key, because that's what sets their timeline. If he leaves work at 2:02 and it takes him 20 to 25 minutes to get home, puts him on the driveway right after the 2:13 bridge guy video, and it fits. They can make it fit their theory that it was one guy, and this was the time frame, and this is how it happened, and all of that. So it's the missing piece that ties it all together. Mr. Baldwin did the cross-examination. The first question is, you were out of town the week before February 13th. Mr. McLeland instantly objects to it being beyond the scope. Mr. Baldwin says it's relevant. It's going to be relevant to the issues that came out. And she's like, how? And he says, well, my question will reveal that, if you would like to, have a sidebar. So they have a sidebar. And this is a pretty extended sidebar. Pretty extended sidebar. So when they come back, it's clear he's not going to get to follow this up. So he says, you did not drive straight home on February the 13th, did you? And Brad Weber says, that's not correct. And Mr. Baldwin says, you told law enforcement just a few days after the crime on February the 18th that you went to work on ATM machines. And Brad Weber now is, he says, it's not true. And he's angry, infuriated. It's like an instant rage. Take back. Uh-oh. Deliverance moment. Ooh. That's not true. And he says, I dropped off a trailer. He says, I dropped off a trailer. And Mr. Baldwin says, you did that earlier in the day. And then Mr. Baldwin walks up to the stand and hands him a piece of paper. And he's handed him a subpoena right there on the stand. Boss move. Boss move. That beyond the scope, they're going to be coming back to it. They're going to be coming back to what Brad Weber was doing out of town the week before February 13th. They subpoenaed him on the stand. It made me wonder if he's been evading service, if they've been trying to, and they haven't been able to serve him. Because, they could have served him before. They were ready with the subpoena. It didn't look handwritten. They were ready with it. Served him right there on the stand. Freaking boss move. Doesn't happen very often. Don't see something like that happen every day. So with that, I am so ready for the defense case. Got one more witness to sit through. We know that it's going to be Mr. Harshman, I can't remember his first name, Mr. Harshman. He's the one that's going to introduce the like authenticate the video and the phone recordings from Westville. So we're going to be watching a lot of video tomorrow. That's what Mr. McClelland already told us. And I expect the main focus that the state is going to want to have is that phone call that Mr. Allen had with Kathy, and if there's any other phone calls that he was making to family, which it sounds like there was. The one that we heard about, he says, I killed Abby and Libby, and Kathy says, stop saying that. So it sounds like he said it to them before. It wouldn't be the first time. So we're probably just going to hear more of that generic, and now I'm curious too, because we're going to hear the tone. We're going to hear his tone. How is he going to sound when he's saying these things? Because we have that baseline now. We got the interrogation video before he went all downhill. All because those investigators just had to bolster themselves about how he was lying because of his demeanor. Because he shifted his demeanor. If they had never brought that up, seems like a decent chance to me we're not seeing those videos. It didn't seem like Mr. McClelland was bringing them in. It didn't seem like the judge was allowing them in. Mr. Baldwin's dropping all these hints. Those videos would just be the best evidence of the demeanor, wouldn't they? Trying to get the jury to think, why isn't the state showing us these videos? Yeah, we got that baseline now. And we're going to get to compare that to the phone call. We saw him interact with his wife on this video. And now we're going to get to see another one on the phone call, before and after. There was a moment at the end of trial that has me, or at the end of the day today, that does have me a little bit nervous. So they had this, they go and have a sidebar after, and it's a little bit weird. The judge calls them over to have this sidebar. They come back. And the judge goes back onto the bench, but she goes over to the other side and she talks to one of the bailiffs. The bailiff then goes back into the jury room, and we all sit there for kind of a minute, and then comes back into the courtroom. And at that point, she just says, "Okay, court is now out of session." That raises red flags for me, because it makes me concerned if there's some jury issue, or maybe she just had a question about the jury. He went to go check on something and came back, and she's going to, talk with him in private once they're no longer on the record. It was just weird that she didn't take us off the record. I don't know what that was about. It was strange. It makes me a little bit nervous that there might be a jury issue, and that's why she kept us on the record, because she was waiting for him to come back. And if there was something, maybe it would have been taken up, because we did finish early today. We finished at like 4:00, which was awesome, because I was able to bang out nearly everything, the final everything that I need to get done to file this writ petition. So close, guys. I'm like minutes away. It's not going to take me hardly any time to wrap it up. And you have to send it to this, like, it has to be like pre-reviewed. You send it to this special email address, and they pre-review it and then tell you when it's okay, like you've done it right, and so you can go ahead and e-file it at that point. So I should be ready to do that probably before I go to bed tonight. Thank you for the early finish today. That was really a gift to us. I certainly appreciated it. There was also just a lovely little kind of moment, just a little interaction that I saw that I thought I would share with you guys, because Mr. Baldwin was standing next to Mr. Allen. They're both standing up. Everybody's like getting up, kind of getting ready to leave the courtroom. So we're all just standing around. Mr. Baldwin is starting to cough. And Rick reaches over and he claps him on the back, and he's smiling and laughing with Mr. Baldwin while he's clapping him on the back. And it was so far just the calmest and the happiest and the most normal, and the closest thing that I have seen so far in this entire trial to that. Kind of looks like that could be hints of that old Rick. We didn't see him laughing and smiling in the interrogation videos. There's nothing to laugh and smile about. But it was a genuine, it was relaxed. It was a connection, a good connection that he has with Mr. Baldwin. I always appreciate seeing that type of relationship that attorneys have with their clients. Because it's a very special relationship. You get to know people on such an intimate level when you're working on their case, preparing for trial, especially in a case as serious as this, where they really need to know so much about him. They need to know so much about his background, and there's a trust building process. And boy, did that trust building process get challenged in this case, didn't it? Didn't it? I mean, time after time, trying to undermine that, get them removed from the case, get them thrown off like they'd done something wrong, bring them up on contempt. Tried real hard to interfere with that, and it does not look like it worked. So, state is just about out of time here. They're just about out of time. They got that. The white van. White van isn't good. It's not great for Rick, but I'm already primed for whatever the defense has got. Subpoenaed him on the stand, man. They got something. They asked me to wait. Can't wait to see what it is. Let's go through some of your comments, guys. We've got a few super stickers here. Thank you so much for that. Bluefish and Joanna Wren too. And Jane Richards with a $10 super chat. Thank you so much. The crypto tax lawyer. Do we know if RA was treated by an actual MD psychiatrist during this time to monitor his meds? No, it doesn't seem. I mean, we don't know. They didn't say specifically. The only reference we got to Dr. Martin specifically was when they were talking about the involuntary administration. When it came to his other meds, like his Prozac, the only thing she referred to was being able to get like a potential record from the nursing station that they would basically have tracked whether they had issued it to him. And so that was the only way that she would really have, besides a self-report, to determine if he was medication compliant. They don't do, clearly any type of, titration or blood checking or anything like that. But it seems like they have to, right? If he's being administered Prozac, there needs to be somebody overseeing that. It needs to be somebody with prescribing authority. She obviously doesn't have that, but how involved in the treatment? That's certainly a question. Very much a question. Katie K, thank you for your selfless work, Andrea. I can't imagine the daily torment you're taking on. Please take care of yourself. Well, it's day to day. Some days are rougher than others. And I said yesterday was a gut punch. It really was. It was so hard to listen to that and to just have it in our faces, like how inhumane this whole system is. These people, these participants, the way that they just didn't even care. They don't see Rick as a human at all. I'm not like a super sensitive person, but I kind of am sensitive to stuff like that. When you have somebody that's the underdog, I'm always a fan. I'm always inclined, to want to side with the underdog. And in this particular case, where it's like I feel like there's a lot of reasons to think, he should win. He should win this case. And so it's just, I can put myself in their shoes. It's hard for me not to imagine what that was like, and just how horrifying that is, But today was much better. Not perfect. They got a hill to overcome, but they could be in such a worse position at this stage in the case. Normally, when a case goes to trial, like a good case goes to trial, by the time the prosecutor is close to resting, the defense should be so far on their back foot. They should have so much ground that they need to make up. And we're not there. I'm seeing it as like they got to get past this white car. They got to get some kind of like humanizing of Rick and understanding why he would say these things, where the information might have come from, what sort of things about him would motivate that. That's all I really see that they need to overcome. The bullet, I mean, I don't feel like the bullet honestly is that strong anyway, but yeah, they can take some shots at the bullet. But it sounds like they got more. It sounds like they got more than just what they need to go back and pot shot, the state's case. They got more. So in that sense, today was a very good day for me because it seems like it's a turnaround. And I don't feel that this man has been treated fairly. At this point, with one witness left to go, where we already kind of know what we're going to see, I don't think he's guilty. I don't think they proved it. I don't think he's guilty. I just don't think enough adds up. The big thing for me is that the timeline is so dependent on those witness descriptions, those eyewitness descriptions, and they don't describe him. They describe somebody completely different. So to me, the simplest explanation for all of this is that Rick got his timeline wrong. He just got his timeline wrong. The first time he went and talked to the police, he really was there at 12 to 1-ish. But he just, misestimated. He was thinking it was later for some reason. Who knows? To me, that seems like the most logical explanation because just none of the rest of it really adds up. The crime itself, no, I'm not. It doesn't add up with the crime of opportunity. I'm not buying that. I'm not buying that. He did not put those sticks on those girls to cover them, to conceal them. No. Not with the massive amount of leaf litter right there to conceal them. You didn't do the sticks. It was ineffective. It was more work than was necessary. And you haven't explained Abby. You just haven't explained Abby. There's big open questions about what happened to Abby. I'm reasonably satisfied with the explanation about what happened to Libby. It does. It makes sense to me. And there are some questions I feel that were answered about Abby. Why they think she was clothed at the time that she passed. That makes sense to me. Yes, it would have smeared. It's right. Like these blood flows, they are very clearly blood flows. They're distinct. They have, like very distinct margins. They're uniform in like how thick they are. It's not like a smear where, there's like a pattern to it and the edges are all diffuse and stuff like that. Yeah, it makes sense that it would have smeared. And it also, because the neck was so bloody, it would have transferred. It'd be very difficult to put somebody's hands and arms through this very, very bloody sweatshirt and not transfer that. Possible it was clean. It was clean when they took it off. They put it on her while she was still continuing to bleed. Maybe that's possible. But still seems like it would have smeared. It would have smeared the blood unless her head was positioned in a way to create that type of flow after the sweatshirt was already back on her. A lot of questions still about Abby. The hands, the clean hands. Very, very difficult to explain. They couldn't explain it. Never seen it before. Never seen it before. Could be that she was bound, but there's no evidence. She has no marks of that. Could be that she was unconscious. There needs to be a mechanism to make somebody unconscious, and there doesn't seem to be evidence of that either. If there was toxicology, we would have heard about that from the pathologist. If they had been drugged and made unconscious, we would have heard about that from the pathologist. I don't know of any drugs that would leave like no residue within 24 hours later. I mean, maybe there are. I'm not, I don't know all of the knockout drugs. But typically, there's going to be that would show up in the toxicology. So they're not drugged. Don't think they were strangled. Don't think they were, suffocated. And the reason why I say that is because it's possible. I suppose it's possible, but it's very difficult to do something like that. Like it's very hard to seal off someone's airways in a way that is, complete enough that they would pass out. But then you also get into that problem. He talked a little bit about the phenomenon when your brain, so you stop your breath, your brain oxygen gets low, and your body overcompensates, and so your heart rate goes up, and your blood pressure increases. And when your blood pressure increases, through that or even like strangulation, it will often create what they call petechiae. You get basically exploded blood vessels in your eyeballs. And it's very distinctive. It's very noticeable. It's very common in cases of strangulation. Now, yes, it's not there every single time. So I can't say it's impossible that they did that. But the other option is restraint. That was their other explanation, restraint. And I don't see a restraint possibility with a one-man perpetrator. How do you restrain both of her hands and still cut her neck? You don't have 3 hands. You don't have 3 hands. I think they still got serious problems with Abby, and it doesn't look like a crime of opportunity. So yeah, at this point, I don't think he did it. So from my perspective, today was good because I think we're starting to see the turn. We're starting to see the turn where now the defense has been waiting for a long time to tell us what they think happened. And we may not get to hear a lot of it, because we can't hear the third party culprit stuff. But I'm very, very intrigued to see what they're going to be able to come up with. Heidi Opp, thank you so much for covering this case. I feel that you have the very best note-taking of everyone. I listen to every minute. Well, thank you. I've had more than one person now come up and ask to see my notes and ask me like, do you know shorthand? I'm like, no, I'll show you. Like it's straight up longhand, straight up longhand the whole way. I'm conditioned to it. I can just write really fast. It is not the cleanest writing. Sometimes even I have a little bit difficulty reading it. Most of the time I can read it pretty well, but I just write fast. I don't know. Figured out how to do it. But thank you for that. I appreciate your comment. The crypto tax lawyer, Andrea, you'd be proud. Went to court for the first time in a decade to get restoration of firearms for a childhood friend. Yes, good for you. He spent 4 in prison for trafficking at 18, 43 now, and successful business owner and anomaly. We got VAF and UPIN today. Congratulations. This is reentry. This is a success story. This is rehabilitation. This is what everybody should want. This is how the criminal justice system is supposed to operate. You don't suffer lifelong consequences for some stupid mistake that you made when you were a dumb kid. And that's just a lot of what happens. A lot of what happens. So good for you. Good for you. Good for your friend. It's a good feeling. And I know it's a good feeling because it's like a basic dignity thing. It may not seem like, just having a right to own a firearm or a right to vote or, right to go to Canada. These things might seem like kind of small things, but they do. They just go to basic dignity because every single time you can't go to Canada or, you can't go to the range. You can't defend yourself in your home. You're reminded that you're a second-class citizen. You're lesser than your sub. You're part of the criminal subclass. And so it's important that people have opportunities to climb out and that there are people waiting for them with helping hands. That's how the system is supposed to work. So thank you for embodying that and making that real. Glitter Beauties. Melanie Little covered the defense's new motion in her live today. It mentions Kevin Fields and Brad Holder. It was masterfully worded. Do you think Gull will allow it since the door was opened? Oh boy. Well, I haven't seen it yet. I don't want to be up too late tonight. My first priority is going to be cranking out this writ, but if it's not super crazy late, I might have to take a little peek. Otherwise, I'll try to take a look at it tomorrow before the stream. I'm intrigued. It sounds like they think a door has been opened. I kind of suspected that there would be an argument that the door was opened because there's just been too much hinting. We kind of knew it was cracked when he was allowed to ask about the posing of the bodies, and just the state has been allowed to offer a theory of what the tree branches mean. And the defense needs to have the ability to counter the state's theory and present an alternative theory. And so maybe these things will open the door the entire way, but they really seem like they need to get something. Or you really are just putting roadblocks in front of the defense that they should be entitled to. I mean, that's fair. That's fair sportsmanship in the trial. And then the comment about the undoing, as a motivation for what it meant. We're going to get into psychological reasons why they might do it. Well, that's potentially opening a door. Why do that? That one seemed unnecessary. But I will have to take a look at that. I am looking forward to it very much. Becca Wee, I think that's Wee, Wisconsin. I emailed Indiana Supreme Court to demand public access. I know, but I felt better. I get it. I understand the feeling. And, maybe they will have that in mind when they get the writ and they hear what I tell them about how this process is going and why it matters. And, they will take that to heart. Aries 414, Andrea here too, and I was also born on Easter Sunday. Nice. That's a remarkable convergence of events. I just wanted to say thank you for not only reporting on this case, but reporting on it the way you do, in a factual way with great explanations. You are appreciated. I really appreciate that. It means a lot to me. I am not used to being the factual reporter. I've said this before. It's a new role for me that I came into it with some discomfort because it's just not what I'm used to doing. I'm used to having the source material, the document, the transcript, the trial stream. I don't have to be responsible for telling people what is happening. You can see it with your own eyes. So it's like an additional responsibility. I'm not a journalist. I don't have any training like that. And I'm used to, in my analysis, sharing a lot of myself with you, a lot of how I think and my background and where I'm leaning and how I think things are landing and stuff like that. And I always say you can take all of it with a grain of salt. It's just, it has as much value as you want to give it. I don't claim to be any type of authority, and I'm just kind of one person with an opinion among many. So the fact that people are appreciating the factual side of the reporting, that really does actually mean a lot to me. It's very encouraging to me as far as like potentially doing more of this in the future. There's plenty of courtrooms that don't have good public access. Most of the federal courts, for example. So maybe it's something that if it's working, I'll look into doing it some more. So thank you very much for that comment. I really do appreciate it. Kalista, do we know if he had a lawyer at the time he was handed this discovery? Yes, he did have the lawyers by the time he got the discovery, because the discovery is transferred through the lawyers. I don't remember the exact date that he got lawyers appointed to him. And I didn't even remember. We were trying to think of the timeline this morning. I'd have to look at the docket to be sure, because we were trying to remember whether it was Judge Diener or Judge Gull who appointed Baldwin and Rosie. I couldn't remember. I was inclined to think it was Diener, but I remember it took a long time for them to get appointed. And so it could have been Judge Gull. But it was I want to say like 3 weeks to a month after he was arrested. It was after the safekeeping order was issued, but yeah, it would have been well before discovery. The squid, was it ever explained why he was placed in solitary in the first place? Your description of the interrogations didn't exactly describe a scene where RA was getting violent, so I'm not seeing a reason. Oh, no, it was for his own good. That's the crazy Darvo gaslighting part of all of this. It was for his own good because they were concerned about being able to keep him safe. He's under a safekeeping order, and the local jails, they wouldn't be able to protect him from the other inmates. That's essentially what they're getting at. They wouldn't have a place where they could keep him secure and isolated from other people. And so he would be at a risk of being harmed by somebody just because of the notoriety of the case. There is some truth to that. There is some truth. A case like this, especially involving children, this high profile. Yeah, I mean, okay, I don't personally remember the name of the guy who went and shanked Jeffrey Dahmer, but a lot of people will. You get status. You get status in jail and in prison by pulling something like that off, especially with somebody who everybody thinks hurt kids. So it's true, he would be at risk in a general open population. I find it very, very difficult to believe that they couldn't manage him in a local jail because they are managing to do it right now. He's over in the Cass County Jail. So why he couldn't have been there from day one looks pretty deliberate. But that's the whole explanation. It was for his safekeeping. They couldn't keep him in the local jail, so he went to DOC. Once he's in DOC, they got to decide where's the secure place to keep him. Well, he can't be in general population for all of these same reasons. So that leaves him with solitary. That's their reason, because it was for his own good. Isn't that horrifying? Pine Rider. Retired boomer, been attending local courts for about a year. Good for you. That is awesome. The court bailiffs and clerks love to chit-chat before the judge shows up. Learning fast. Hopefully others can do this as time permits. You are inspirational. That's great. Yes, the clerks and the bailiffs, they know all of the dirt about the courtroom. Always, always, always treat the court clerks and the bailiffs with the utmost respect because they have a lot of power in that situation. And if you make friends with them, I mean, don't necessarily make like Becky, what was her last name? The Murdaugh clerk. Don't necessarily like make that good of friends with her. But yeah, you can get some real insight that can be very, very helpful about all kinds of things. Is the judge in a good mood today? Good day to file this particular thing. What does he think of the different attorneys? A lot of little inside stuff that can give you some information. Now, I'm saying this as an attorney, but too as a member of the public. Boy, the information the clerks have is massive. They know so much. They know more about how the court operates than the judge does. The judge just shows up and gets the benefit of everything that they do to manage the files and store the files and secure them and send out notifications and process the money and keep track of the records and enter the things in the databases. Like they do the day-to-day work, the hard, bottom line stuff. That's just part of the bureaucracy, really. They do all of that. So they can tell you so much about their court process, and it can be very interesting and very helpful. Annie Clark, appreciate you, Andrea. Peter ran through the defense's new motion to reconsider. Okay, so it is reconsidering the third-party defense a few hours ago. Disappointing, but not surprising to hear that you doubt it will be granted. Well, I haven't read the new one yet. So I haven't seen what their grounds are. I'm skeptical just because of the judge. I'm very skeptical that the judge has the kind of flexibility in her reasoning that would lend her to really revisiting a prior decision. I just don't really see that. I could be wrong though. I could be wrong. I mean, if it does seem like she has kind of been allowing that door to be cracked. So, yeah, I'm looking forward to reading that motion. I'm very interested in seeing what they have to say. Court Girl 5150. Were you following Brittany? Were you following the Brittany case? Thank you, Andrea, for everything. Can you share your PayPal name so we can support you directly? You are truly appreciated. PayPal, I don't typically share it. I will just go ahead and tell you I'm under a Burkhart law. I don't link it. I do have direct support options under the Buy Me a Coffee, which you can find in the channel description. So they're like similar to PayPal. It's a little bit better than supporting through YouTube, just in terms of, YouTube takes a big chunk of stuff. Big chunk of what you donate goes to YouTube. So those are both options. I probably won't promote the PayPal loudly, but Buy Me a Coffee is always a good option too. So thank you so much for that. I do appreciate that. Jason Sorensen, I'm speechless. There is just no way to even describe how insane this is. These people are monsters. The judge has gone full on corrupt. The world needs to see this, and we need to do whatever it takes to get this out to the world. Thank you for all you're doing. The world does need to see this. So I had a great moment today when I left court, because I got to meet some fans. I have fans, wild, crazy. Never really saw that coming, but very, very nice people, and very happy to see me, recognize me right away. Andrew, love what you're doing. And so she had a sign. That she had made. She's standing out on the sidewalk in front of the courthouse with a sign, and the sign says, "No cameras, no wonder." Genius. This is a great sign. I loved this sign. Yeah. Bottom line, no wonder. After having seen what I have seen in there, I know exactly why they didn't want those cameras in the courtroom. They did not want us seeing any of this. They didn't want us seeing any of this. This is why the media, the mainstream media, got the preferred treatment, because they were going to be the source of the information about this trial, about what was happening. And they struggle with it. Not just logistically, but just because they aren't trained legal professionals. They don't always understand the significance of what they're seeing. And so in terms of the details that matter, aren't necessarily going to catch it, aren't necessarily going to get the full flavor of what's going on in there the way that somebody who does trials is going to see it. So they didn't want us to see any of this. And boy, did we throw a wrench in their plans. We really threw a wrench in their plans. So we're going to keep working on it. We got to get those recordings, got to get those exhibits. So taking it up to the next level. Let's be realish. Alan may have legitimately seen the white van while hiking. He was there after all. The state is grasping. Thanks again for the hard work. The problem is he didn't go across the bridge. And so he wouldn't have been in the right position to see the white van. Now, I say that I don't know what it looks like out there in February. I guess it's possible, now that I think about it, all the leaves off the trees. Because I was thinking when I was out there, you can't see anywhere near the end of the bridge from that first platform. You can't see anywhere near the end of it's a long, long bridge. But I don't know what it would look like with the leaves off. I don't know if you could see all the way. I don't know if you could see down to the bottom where the road goes. Yeah, I guess maybe you could. I guess probably you could. That's a very good point. Could have just been standing up there and seen a van go by. Not impossible for sure. This is a good idea. Sarah S. Seeing the boss moves is just yet another reason to have cameras in the courtroom. Glad you got to witness it. It was great. It was a moment. Yeah. I mean, talk about tantalizing. I'm so ready for this defense case. Carazola X, my cousin Vinny on the TV, couldn't help but think that if the movie was a little more like this case, imagine Joe Pesci trying to defend something like this. Yeah. I mean, the case is so bad, I could almost see him bumbling his way into having the Perry Mason moment, It's just a bad case. It's not good. And it doesn't look like Brad Weber is going to do it any big favors. Tier Talk, from prison to true crime. Well done. Love the content. I just posted a video up about how the Reed technique was employed during the interrogation of Richard Allen. I just hope I can compliment the excellence. Well, I will definitely go check that out. I'm going to encourage everybody to go check that out because yes, the Reed technique It's like, it's a thing. It's a thing. And like, I don't even know it like on a real sophisticated level. Like, I've never been trained to do it. I just know, very generally, like, I couldn't tell you off the top of my head what the actual steps are. I know that there are steps. I think there are 9 of them. I just remember, a lot of the broad parts that really stand out to me as being particularly problematic. And the little things like the interrupting the denial. I'll never forget interrupting the denial. Because they literally won't let you say you're innocent. Like, that's part of the technique, is not letting you say that you're innocent. Like, shut up, you did it. And that just tells you everything you need to know about this technique and what it's really designed to do. So I will definitely check that out. I look forward to seeing that. Rochelle D, that special cabin shack is just a hop, skip, and jump away from the Webbers on the map. Convenient? Yeah, there were those outbuildings that nobody ever went and bothered to check. Right there at the end of the driveway. Remember, Mr. Weber had a .40 caliber Sig Sauer that they seized, compared the bullet, could not exclude his gun. I haven't forgotten that. So, yeah, I'm kind of suspecting that this is a situation where perhaps, there were a lot of false alibis in the early investigations of the case. I remember Ron Logan. Ron Logan had somebody fabricate an alibi for him. I can see a situation where Max Weber, initially, when this thing first happens, he's got to distance himself from the timeline and from the area. He doesn't want to be under suspicion. So he places himself far away from the crime scene at the time that they are trying to allege that the murder happened, or that the girls were abducted. That 213 timestamp is real important. So yeah, he could have put himself far away, and now it's going to come back and bite him, because now he's trying to put himself, there at a different time to help the state. Why? I don't know, but I hope we find out. Rochelle D, so glad you got your stuff done, Andrea. Please get some R&R. We need you. I am going to be in much better shape tomorrow, and from there it is smooth sailing. It's already Thursday tomorrow. Yeah. It's going to be good. And then we're going to be in the defense case. We're going to be just a few days from sleep in Sunday. A little Saturday afternoon, get some outdoor time. I don't even care if it's like pouring down rain. I'm gonna take my umbrella, spend some time outside. You don't have to worry about me. I'm very good with temporary hardship. It's not a problem. Jenny! That's a great name. Have they compared the voice on the Down the Hill vid to RA's during interrogation? I'm not aware that there's been anything formal. Certainly the prosecution didn't do that. And we already know the prosecution is doing as little as possible at this point. That, part of the reason why is because they don't want to get anything that might tend to undermine their theory. It's already so thin that if a hole gets poked in it, it's potentially going to cause the whole thing to collapse. And so if they get an audio that comes back that says the voice isn't Bridge Guy, his voice isn't Bridge Guy's, and we already know the descriptions aren't Bridge Guy's, and we know the sketches aren't Bridge Guy. There's a reason why they didn't do a height analysis of Bridge Guy, because if he's bigger than 5'5", they got a problem. So they don't want those answers because they know how weak their case is. And frankly, I think they probably know. They probably know that it's not him. They probably know that. That's just, you think about that, assume that, and then think about if you knew that you were prosecuting a guy that didn't do it, how would you behave with your investigation? Just think about that. You think, it puts a lot of things in perspective about the behavior and the decisions that were made. There's a reason why they didn't compare his hair to the hairs at the scene, even for investigative purposes. There's a lot of decisions that were made, roads that they decided not to go down. Didn't ask those eyewitnesses. That guy you saw on the bridge, is he sitting here in the courtroom today? Asked plenty of other people that, but didn't ask the critical witnesses that. They know how weak their case is. So no, if anybody did that, it would have been the defense. And I doubt the defense has the resources to be able to do that, honestly. I mean, we'll see. We'll see. Sylvia S., have a drink on me. Thank you. I will. I am really fixated on my water right now. I'm just trying so hard to stay hydrated. It is still a challenge in the courtroom, but we're doing better with the breaks and stuff. So it does help, but the dehydration really gets to me. So once I get nice and good and hydrated, I'm going to go out and have a Manhattan on you. Thank you for that. PDF photography. So they can use his statements to doc where he says, I'm guilty, but not the ones where he says, I'm innocent. Make it make sense. Welcome to criminal justice. Them's the rules. Them's the rules. Self-serving hearsay, they call it. It's self-serving hearsay. Yep. You got to get real creative to get your client's own statements in. And so they will go through, prosecutors, they will go through, you'll have like an interrogation, and the person will say like, like 20 exculpatory things. And then one thing that is like maybe mildly incriminating. And I say that because you see how the Steve Mullins and the Holmans, the Jerry Holmans of the world interpret, red flag statements, things that, are at best ambiguous, and at worst are like completely normal, not really suspicious at all. But they just find a way to try to make that like really super incriminating. They will go in and they will pick that thing out, and that will be the only thing that they present to the jury. And unless you have a good judge who's a fair judge who appreciates the importance of the defense, you might not get to put in anything else to put that in context. So yeah, that's the system. 6 Kids UK. As a pharmacy technician, Rick Allen could easily self-medicate. That's actually very true. I hadn't really thought about that. Yeah, I don't know. Gingy Probs. The bullet keepsake has been on my mind, but I realized if I survived a crisis, great point. I might keep a token as a reminder to extend myself grace. I might also be reluctant to disclose that to outsiders. You are a genius, Gingy Probs. I hadn't even thought about that, but that is a really, really good point, because we know he had that incident. And he got hospitalized, and it sounds like it was a one-time thing, 2019, not since. That's a pretty good run, going a few years without having some kind of recurrence. Yeah, you might keep a keepsake. You might. You are a genius. I love this idea. Karen Payne, check out Jay Vermillion's suit against Westville. I will check that out. Is that the one? That they talked about in the pretrial, or is that like a new one? I know that there are several. I'll write it down. Jay Vermillion versus Westville. I'm afraid I won't enjoy the details, but it's important to see this stuff, so I will take a look. Judy E. with a super sticker. Thank you so much for that, Judy. Let's be realish. Did the state mention the saw cut stick at all to get out ahead of it? No, nothing. If not, then I'm looking forward to the defense bringing that up. Yeah. Yeah, because he didn't just pick up sticks from the ground to cover up the girls. He cut one off the tree. I can't wait to see which stick it is, because some of these sticks, they're like as big as my pinky finger. Yeah, he really went to the trouble to like cut that off the tree, to place it, to hide them, to conceal them. It's absurd. Like, how dumb do they think we are? Nope, never got out in front of that one. Joey Pie. Oh, I'm sure the explanation will be that it had already been cut. Somebody else did that, in this area that they've gone to great trouble to establish almost nobody would go through, because otherwise you have potential problems for the contributor of the bullet. You got to make it a very isolated, nobody goes their place, but you can't have really both a bullet and, somebody showed up there and sawed a stick unrelated, and one is totally unrelated and one absolutely is. Like, it's absurd. Joey Pie, what would it take for you to change your mind about Richard Allen's guilt? Well, what I had said before is that I needed something from these confessions. I needed something definitive that really was a detail, like some kind of detail that can be corroborated, that is something that only the killer would have known. And so my first thought about that, after we got, more details about how all of this went down, vertical cuts on Libby. Like, that is unusual. That is not expected. The number of them, those are very specific details that only the killer would know. 3, vertical. It's actually like 4, but, looks like 3, vertical. If he knew that, he confessed that while he's in prison, I think we're done. And it's before he got the discovery. We got to really qualify that, because the problem is, once he gets the discovery, he knows everything about the case. There's no longer anything that only the killer knew. Everybody that had the discovery knew it. So that would have convinced me of his guilt. I think if the descriptions of Bridge Guy had been more like Richard Allen, I'd be a lot closer to guilt. I think if they had gotten any speck of DNA, even like trace DNA, guilt. I think if they had searches on his phone that were like, the preparatory stuff, any kind of contact with them, any kind of like connecting on their social media, any type of just generic aspects of how to commit the crime, research types of things, we're a lot closer. I mean, it's a circumstantial case. It's almost always a circumstantial case, because you almost never like catch a murder on video, if it's not a circumstantial case, it's usually a confession, and it's a confession that's corroborated by other evidence. So that's really direct knowledge. So it's always circumstantial, and it comes down to how well do the circumstances reinforce each other. You can't just have like one thing that kind of makes you look guilty. The reason why circumstantial cases work is because there's a lot of corresponding things that reach the point where it becomes very difficult to explain how all of these could simultaneously occur by coincidence. And I know a lot of people think that has been met in this case. I understand that. I just very much disagree, because I think that part of the reason why that has been like the story that's been grasped on is because it has become clear how misleading those basic fundamental facts are. He put himself on the bridge. Well, I mean, yeah, he did, but which time? Which time did he put himself on the bridge? Because him being there at the time that the state wants him there isn't very well corroborated. It's not very well corroborated. Now, if they had his license plate on that car at the Hoosier Harvest Store, yeah, now we're getting closer. We're getting a lot closer. So he put himself on the bridge. He really didn't. He put himself in the clothes that the bridge guy was wearing. No, we just saw the interrogation. He didn't at all. They took that and they distorted that. He just said, could have been a blue or a black coat. He actually thought it was a black coat. He actually thought he was in tennis shoes, and that he would have had a skull cap in his pocket, but he never said he had it on his head. He parked at the CPS building. I haven't seen that confirmed. The state hasn't put on a single witness who said, I saw a black Ford Focus parked at the CPS building. Big hole. Big hole. All they got in this time frame is Betsy Blair seeing what looks like a Mercury comet. You got to connect Rick Allen with a Mercury comet, or you got to put one of his cars in that parking lot. And they don't have either of that. Not in the time frame that they need. So, yeah, I don't see that. I don't see that. And then the confession on top of it, the bullet on top of it. The bullet to me is junk science. It carries no weight with me. It really doesn't. It really carries no weight with me. And the confessions under these circumstances can't give them a lot of weight either. So they're not nothing. They're not nothing. But are those things sufficient for me to convict a man of a murder and put him away for life? Absolutely not. Absolutely not. That's not enough to convince me he did it. That's, for me, well within the realm of coincidence and just normal range of error. If you're gonna rely on junk science, you're gonna have a range of error with doing that. And I've said before, if you want an example of what something is, in my opinion, like a really, really good example of a circumstantial case that's built like that, with those kinds of overlapping circumstances where it's just this confirms this, confirms this, confirms this, confirms this, and we don't have him on camera, and we don't have a confession, we don't have anybody saying that we saw him. But there's just so many circumstances that are difficult to attribute to being coincidental. Go look at the Lisk case. Go look at the probable cause affidavit in that case. It's damning. It's damning. It's extremely compelling. It's going to be very, very difficult for the defense to overcome that. So this is just not that. My opinion, this is just not that. Heather Brown, you're fast becoming a favorite for information. Well, I'm glad to hear that. I appreciate that. Really appreciate everybody's support. Catitonia, Anita W. with a super sticker. Thank you so much. Rochelle D. What was Libby doing if she was not injured yet, but was disrobed and cold when the assailant was busy cradle carrying Abby without his knife, box cutter, or gun? Pieces are missing in this scenario. They really are. That's been a big, even before we saw the crime scene and all the details and all that stuff. It was always a concern for me about how does one person restrain two girls while killing one of them. It just doesn't make sense. You're going to have to focus on this one. How are you going to do it both by surprise, without any kind of resistance, without any defensive wounds? How is one person going to restrain a girl, kill her, like while killing her, and where's her friend? In front of her friend? What's her friend going to be doing? Her friend is going to be screaming. Her friend is going to be running. The single perpetrator is really, it's always hit me wrong. And the more we've known about it, just the less likely it really seems. I just don't see how they could do it. All it takes is once. Are A and L's family okay during this? I think so. I mean, it's hard to say. They have a lot of support. They seem to be in good spirits. They certainly have their hard days like everybody else does. The crime scene day was bad. It was a bad day for the family. Of course, it's going to be horribly, horribly upsetting. There's absolutely nothing that could compare to having an experience like that, but they are holding up okay. They seem to bounce back. And so like today, everybody seemed to be in good spirits. And I hope they are. I really do wish them the best. I don't know what their thoughts are about all this, what their inner feelings are. I'm not the kind of content producer that's going to be like out trying to knock on their door, out trying to interview them, intrude in their grief. I'm much more, I'm more the kind of person who's going to watch from the distance. In part, that's just because it's this court process that really is my focus. So I'm not like looking to have an intimate relationship with them or anything like that. but I certainly wish them well. And I do. I want them to have peace, of course. Everybody would want them to have peace. We'll see. We'll see how things go. Carrie Mache Goal appointed the two lawyers, Baldwin and Rosie, who ordered him to prison. It was Diener that signed the safekeeping order. I knew that, and that's why I wasn't sure about the sequence of events there. I knew he had done the safekeeping order, and I just couldn't remember how soon after that counsel got appointed, and then the whole recusal and replacement, the appointment of Judge Goal. So that helps. But yes, it was Judge Diener who did the initial safekeeping order. They did move. Baldwin and Rosie did move to modify it to get him held locally, and the state resisted, and Judge Goal said no. He's fine. Actually, he's being treated better. She bought that. She bought it hook, line, and sinker. He's actually being treated better out there than the other inmates. It's a pretty disgusting order, from my opinion. When I read that one, yeah, it turns my stomach. He's treated better out there. No cameras, no wonder. My Passenger 33, there are several Water County jails in Indiana that are federal holding facilities, so there were many options other than the max prison. Interesting. Yeah, see, I don't know. I don't really know what the facilities are. The more options there are, yes, the more it makes this one look like a deliberate choice. And then if this one was a deliberate choice, really does raise a lot of questions about why they chose this. Why did they choose this one? They chose where they would have to deliberately violate the policy that arose out of a finding that the prison conditions were violating the 8th Amendment, the prohibition against cruel and unusual punishment. They would have to have literally chosen that option over something that didn't. It wasn't a potential massive liability and just inhumane when it comes out that's what they did. So they chose it for a reason, and then you got to start thinking about what that reason was. What was that reason? Was this the plan all along to try to break him? Were they just being punitive and didn't really care what happened? I don't know, but they certainly weren't upset about what they got, the fruits. They weren't ashamed of them at all. They've been waving them out in this courtroom like they're trophies. These confessions are like trophies to them. Skeptic Neurons, new member. I listen to everyone in court every day and do find your notes most consistent. So thank you for that. I'm not sure on RA guilt yet, but his treatment and this judge scare me. And that's just part of the whole reason why this case is so concerning on so many levels, because there's just so many problems with it, and we shouldn't have to be questioning the integrity of the process. Like, that's the last thing that we should want if we want justice for Abby and Libby. We shouldn't have to be questioning, like, why is this whole thing so one-sided? Why is the defense not being allowed to put on a defense? Why is the state trying to keep all of this stuff out? Why is the state objecting to things that seem like very reasonable things that a jury who wants the truth would want to know? Why is the state being all sketchy with their, distorting and misleading and twisting things around? I mean, some of that's normal, it's just this normal bad prosecution to be vaguely dishonest about what your case is. But, as soon as you have the judge giving them the assist, well, then now it's only natural that people are going to start to wonder, is that deliberate? And that's, conspiracy. It's conspiratorial. It was unnecessary. All of it was unnecessary. All we needed was just a fair judge to apply the law. And we could have so much more faith in the ability of this process to answer our questions about whether Richard Allen is guilty or not. Sick Reeves is a new YouTube member. Welcome to the channel. Steve WP Mac with a super chat. Arla7247 just caught Nancy Grace. She's pure mainstream. I knew she would be. I knew as soon as she left, as soon as they just heard the details of the confessions and the molested his dog. I'm sure all of that's in her coverage. That came out today, molested, none of the rest of the stuff, none of the credibility problems, none of the circumstances about why he may have said those things. I knew what we were going to get from that. Allie writes, never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it's the only thing that ever has. MM. Yeah, it's true. It's true. And we are stronger together. That is another one. Shauna King, there is a Robinson v. Walla, 2018. Westville correctional mistreatment and going against her evaluation. It is a bombshell of what is happening and what she has done. Wild. Thank you, Andrea. We love you. You guys are giving me the rabbit holes, the side stories to go down. I love this. Walla 2018. I will definitely check that out. That can't be very long after she got to Westville either. I mean, I think she said she started there in like 2018. Yeah, I'll be interested in seeing that. Lisa Thomas, who said this was not a complex scene? I don't remember specifically anybody saying that. To me, it's yes, it's complex. There's a lot going on here. There's a lot of things to figure out. Puddles in all these different places, girls in weird positions, sticks on them, one clothed, one not clothed, one has her throat cut but has no blood on her hands or torso. And it's really not clear to me. I'm still skeptical on the blood quantity, because all there really is what's in her sweatshirt and it's just a tiny little amount that dripped on the ground. And we heard from the crime scene investigator that this would be a lot of blood and that it would tend to pool. And there's no pool. This is blood on the trees, blood on the trees. Like, yeah, there's a lot to interpret here. I think that anybody who calls this not a complex scene is just not really familiar with what the details of the scene are. PDF photography. Any reaction from the jury at subpoena moment? I didn't even notice. I didn't look at them. I was like, I was just so like, oh my God, at what I was seeing, that I really didn't pay attention. I was mainly watching him, the witness, Brad Weber. I was watching his reaction to it. And he was taken aback. He wasn't expecting it. He wasn't expecting it. So I was like, wow, boss move. Just walked right up. I'm handing you a subpoena. He takes it and they let him off the bench and he's still walking out of the room, like looking at it. I didn't catch the jury's reaction. Sorry about that. Susan, just thank you. Thank you for your diligence, huge heart, and integrity. Well, thank you for supporting and for being here and for being the kind of person who says nice things about somebody else to uplift them. I definitely appreciate that. Mick Bartnick, wait, did that come out already in this trial that Brad Weber's gun could not be excluded as a match for the unspent round? It did indeed. It came out with the forensic firearm analyst. She couldn't exclude his gun. There was a Smith & Wesson 40 caliber that she could not exclude. And there was a Glock 40 caliber that she initially could not exclude, but she says now because of the way the order in which their findings went, which there's a problem with this for me, but anyway, if she were reevaluating all of the guns at the same time now, she would exclude the Glock. But still nothing about the Smith & Wesson or the Sig Sauer. All while she's saying she can definitively identify Richard Allen's gun as the source. She can identify his gun as the source, but she can't exclude these other ones. So you can't identify it as the source. So the thing about her comment was she's basically saying it was because the results I got were in part because of the order in which I did the analysis. I examined them separately. If I were examining them all at the same time, it would be different. It shouldn't be different. If it's different, because you're just changing the time, your method is trash. It would be consistent. If you get my blood out of my arm and get my blood type, it should not change between doing it now and doing it at 5 o'clock in the morning. It should be the same. I mean, what a crazy thing to say. Yeah, she did. The Sig Sauer they got from Brad Weber could not be excluded as producing that bullet. Sick Reeves from a law fam. 2 parents were defense attorneys, judges, and appellate judges. My goodness, you are from a law fam. A third is now a prosecutor. I don't think he'd do anything like this, but the more I go in life, I wonder if prosecution can be ethical in this system. It's all sad. Thank you for your work. Yes, they can. Yes, they can. I would say the challenge with being a prosecutor is because most of the time you're a line prosecutor. You're not the guy at the top who makes the decisions, and so it's like law enforcement. You suffer the same kind of trickle down effects that you're going to have under any leadership. The culture starts at the top, and so you're not going to walk in and just be a prosecutor and be the top guy from day one. And that's where you have the opportunity to be the ethical one, to set the standards, and to, imbue that in the people that you supervise, that you train. I've known good prosecutors. I've just known a lot of bad ones too, Jay Margaret is now a YouTube member. Welcome so much to the channel. Michelle C. was investigating the Reed technique this week. Did you know that John Reed runs a consulting firm? Their motto, protecting the innocent and identifying the guilty. Yeah. Oh yeah. John Reed has made an absolute fortune off of this technique. Of course he defends it and, presents trainings on it and stuff like that. His explanation for all of this is always, if it produces a false confession, it's because they're doing it wrong. It's because they're doing it wrong. You're not supposed to use the Reed technique unless you have strong evidence of guilt, is what he says. But what it really means is that, unless you're actually using it on a guilty person, you run the risk of getting a false confession because they are going to treat everybody as guilty. And that's just the reality in practice. That's how it works. They get a little bit of evidence, like how much is enough evidence? Or like back at the sufficient agreement standard, for the firearms comparison. What's sufficient evidence of guilt to warrant using the Reed technique? Yeah, we don't know. And so the cops would always say, well, we had enough. Look at them. They're in here in court in this case, still asserting they have overwhelming evidence. And it's so good that they won't even, they can't even consider alternative possibilities. Not even possible that there was another perpetrator. Not even possible that a car was there and the girls were put in the car. Things that seem plausible, I think, to most reasonable, not closed-minded people who say, yeah, that's plausible. It doesn't mean it's happened. Doesn't mean it's likely, but it's plausible. They would insist. We had overwhelming evidence. The bullet from the gun, put himself at the scene. And they may very well have convinced themselves, after they've distorted all the stuff, that the eyewitness, accounts are him, that they put him there, and and he put himself in the same clothes as Bridge Guy. They probably do think they have overwhelming evidence. Truth Seeker, will you please explain to everyone why RA can't sue after he's found not guilty, please, so they know why he can't, and it's very wrong. That's Indiana. So wrongful prosecution is almost impossible to sue for. Just the fact that somebody has framed you is almost impossible. And in part, that's because prosecutors have near absolute discretion in their charging decisions. This is completely judge-made law. There's nothing in the Constitution about this. Some places might have statutes about it, but for the most part, these originated from judges. And so to the extent that they maybe have gotten picked up and replicated in statutes and in different jurisdictions, that could be the case. But the idea behind it is that prosecutors, if they are too worried about whether they're going to be responsible for a bad verdict, then they aren't going to charge marginal cases. And that's a policy decision, like whether they should or not. Do we want to overcharge or undercharge? There's a lot of room for disagreement on that. The court has come down on the side of it would be too discouraging to them. They wouldn't be inclined to pursue marginal cases. That would mean a lot of people would not get justice. And so because of that, almost impossible to sue a prosecutor for wrongfully prosecuting you. Judge, absolutely no question, is absolutely immune for all of their judicial acts. Why? Because the judge got to make the rule about the judge's liability. Big shocker there. So as far as the prosecution itself, it's almost impossible. As soon as there's a finding of probable cause, that's it. That insulates it. There's very, 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 very narrow exceptions to that. Very unlikely that he's going to be able to pursue a lawsuit against the prosecutors. Now, the Department of Corrections and the prison conditions, there's a reason why all the lawyers were there yesterday. There's three of them, three of them representing the Department of Corrections and the officers, the police or whatever they are. There's a reason why they were there. He looks to have a pretty solid argument there that they, deliberately violated their policies. At the very least, they were negligent, intentional infliction of emotional distress, pretty good case for that. And that's even before you get to the potential for, Eighth Amendment violation, especially if that's already been found in another court. So that, I think, is probably his best avenue. But no, the prosecutor and the judge, they can't suffer consequences like that in a civil suit. That's why the remedy for these folks is political. It's political. You got to vote them out. Judge Gold's up in 2026. I don't know when Mr. McClellan's up for his reelection. I don't know when Sheriff Liggett's up for his reelection. But this case, I'm sure, is going to feature for a challenger. Anybody who wants to step up and throw their hat in the ring. This seems like a pretty good bit of fuel for something like that. So hopefully it doesn't get forgotten. If it's a while before those options come up, that's what it comes down to. If they suck, you got to vote them out. Glenn F. Thank you, AB. You give us a daily dose of judicial education along with reporting on the specifics of the case. Makes me very interested in learning more about other cases. That's great, because that's really my goal. I want to make what happens in court accessible to more people. Help them understand it better, see it a little bit more like an insider sees it. And so if I am pulling that off, that is a great sign that things are going exactly as I hoped that they would. And it's encouraging to me, yes, to keep doing it, follow it up with other cases. Come check out our stuff in Coburger. You got some twists and turns in that one. That is not the straightforward case that a lot of people think it is. Not the straightforward case people think it is. J. Margaret, how is it that someone with more power and morals hasn't stepped in, maybe FBI, and stopped this abuse circus and wrongdoing? How can they not? I said last night, if the FBI and the Department of Justice, if they're not investigating this facility, I don't even know why they exist. Like, it's just so, it's so abusive. It's so corrupt. I mean, I'm not using corrupt in like the technical people. I guess I mean corrupted, that whatever positive penological goal there ever was with this place. It's got lost a long time ago. I mean, this place is a mess, and it's injuring people. And this is our government doing it. Like, why do we have oversight? Why do we have a federal oversight, law enforcement, if this isn't the kind of thing that they're going to be taken on? Yeah, if they're not involved with this, they should be. Claude Simeon, hearsay rules demand we be narcissists who think we are perfect, so we never have statements against our own interests that can be used against us. Yeah, it is true. It is true. Most reasonable people are willing to concede things. Honest people are willing to concede things that maybe aren't that favorable to them. Maybe don't look good. Yeah, I was out at the bridge. Rick Allen never had to come forward and say a damn thing. Never had to. Sketches weren't putting him there. Descriptions weren't putting him there. And in 5 years, not a single other person put in a single tip out of tens of thousands of tips. Not a single one about Rick Allen. He never had to do it. Look where it got him. K159S. What if they used the mystery scarf to cover Abby's wounds when they redressed her by the river? The scarf would have gotten saturated, very quickly. Yeah, I don't know. The scarf is that's a whole thing. Like, I understand why they didn't test it, but it's just so strange to me. You tested everything else in this river, even knowing that it's got the potential for interference, but you didn't test that scarf. And it's the one thing that you're like, oh, well, it also looked like it didn't belong. Well, that's the whole point. That's the whole point. If it doesn't belong with the girls, yeah, maybe it was just a random thing that happened to be there. That's a coincidence. It just happens to be right there where all of this other stuff floats downstream and gets stuck. No, the suspicion is it came from the killer. So why wouldn't you test that? Yeah, Abby is very hard to explain. Very hard to explain. Sunny Jenny, thank you. In Washington, watching after work, it's horrifying to watch the injustice. I'm keeping the families, jury, you observers in my heart. This isn't justice. I keep thinking innocent until proven guilty. Well, so far, it's not, but we're not done yet. We're not done yet. The jury has an opportunity to bring some justice here. It's not perfect by any means, and it's unfortunately, like, we kind of are in a situation now where I feel like justice for Abby and Libby is off the table. It just is. I can't feel that convicting Richard Allen on this evidence in this case, that's not justice for them. I don't think they're getting the right guy. Not based on what I've seen, not with 1 day left that we pretty much know what we're going to get. So now it's just down to Richard Allen and his justice. And they do have a chance there. They have a chance there. So maybe it's a little crumb. It's a small crumb, but it is something that we can hold out hope for. They Lynn is me. First time live playing catch up. Could the upside down F be a Norse Odinist rune? I think that's what the defense theory is, that it was some type of rune. I don't remember all of the details about, there's a lot. There is very, very dense, a lot of this third-party culprit Odinist stuff. So I don't remember all of the details of everything, but yes, they may know what rune it is and what it's supposed to symbolize and have a whole explanation for that. I don't. But yes, I do believe that is their theory, is that it's a rune. Michigan farm boy, I've had shells in my pocket after hunting. They went on my dresser and end up in boxes or change dishes before getting put back in a safe. Random shells could be characterized as keepsakes, etc. Commonplace things can get shown in a harmful light. Yeah, very good point. Very good point. You know, something just ends up in your pocket and you empty your pockets when you get home and you always just stick it in like that one spot on the counter, and then it gets like knocked into a drawer or whatever, and then you forget about it for, however long it takes you to clean out your junk drawer, which is, for me and probably most of us, way longer than it should be. But that's why it's a junk drawer, right? You don't have to clean it out very often. It is. It's a very good point that a lot of innocuous things like that can just be presented in a way that make them seem a lot more nefarious than they really are. But I love that. I love that theory about. It goes back to that 2019 incident. I think that's a really, really good idea. Aftan Archer. Indiana Mitt Spec here. I have so much to say, lol. Well, we would love to hear it. We want to hear it. Courtney B. Check out Riggins v. Nevada and Cell v. US. Yeah, Cell. Very familiar with Cell. Competent pretrial detainees generally can't be forcibly medicated outside of an emergency. Need more than just grave disability. That's probably why all of a sudden they're calling it harm to self. Risk of harm to self. They kept going through with their observations about how he was like equivocal at best, and they never once established any action that he took. Like after saying that the basis for putting him on constant, the basis for putting an inmate on constant is because you need to be in a position basically where they're threatening to act and you can intervene. They never had anything like that with Rick. So yeah, the whole point of sticking him in the cell was that he wouldn't be in danger, and now that's going to come back and bite you. Because how is he supposed to do anything? All he can do is bang his head against the wall, and that's not gonna kill him. So. Yet another problem. Good observation there. J. Margaret, grateful for you, Andrea. I support you. It's refreshing to see how you are able to think objectively, critically, morally, without being gaslighted, blinded by those in power. I wish more people had a good heart like you. Thank you. Thank you. I consider myself a pretty nice person, but like on a personality level, I'm not very agreeable. And I think that's a big part of it. I like to think about things for myself. I don't need to be told. I don't need to be spoon-fed somebody's opinion and told it's a fact. I can figure out the facts for myself. And there's a lot of other people like me out there. I know that. I've met plenty of them. It's just the facts. The facts are the facts. You can want the facts to be a certain way, but at the end of the day, it's only going to get you so far. Yeah, we're all human and we all have our biases, and I try to be very upfront about mine. Of course I have biases. But when I talk about cases like this, I think the important thing to remember is people love to throw out, as soon as you have an opinion about what you've seen, now it's like, oh my gosh, you're biased, your coverage is so biased or whatever. And I don't even usually bother with, I don't care about critiques like that. Like they're really meaningless, but it's just entertaining to me because it's such a misunderstanding of the difference between bias and being biased and being informed. When you're biased, it's because you don't have any information. Like that's literally the point. You're making a judgment about something without specific information to it. So that's why like racism is a bias, because you're assuming that a particular individual that you have absolutely no information about, that they have certain characteristics that you attribute to, a racial class or something like that. It's bias. That's bias. Being informed, you get information, and the human mind, the way that it works, we are made to process information and reach conclusions based on it. That's thinking. That's called thinking. And so I'm sorry to the people who are offended by me watching this trial and thinking, but I'm actually really not. Like, I'm going to keep doing it. So it is what it is. I appreciate all of you that enjoy being here thinking with me. Beagle Mom 7, wondering if the family is starting to wonder of his innocence like I am. Yeah, I don't know. I don't want to mind read. They did look somber yesterday, or not. Yesterday, after all that testimony from the guards and the conditions and everything, they looked somber. Like, I don't think they particularly like that he was treated that way either. I don't know that it helps their case. You know, if they think it was him, I don't think it helps. I don't think it helps that the state put him through this. At best, it's a major own goal to treat this guy so inhumanely when there doesn't seem to have been a need to. And if you had such a strong case without these confessions, then none of this was necessary. I do wonder. Jordan Lanigan, the world needs more Andrea Burkharts. Well, thank you for that. Someday there will be cloning. Maybe it will be an option. J. Margaret, I predict the girls' families will soon be advocating for his innocence, demand a new investigation. Hopefully their pain doesn't blind their reality. Yeah, I do. I wonder what they've seen, and I wonder how they're going to react if he is acquitted. If he is acquitted, and I feel like there's a good chance of that right now. I do wonder how they're going to react to that, because it's going to be tough. I can understand psychologically how you would just be very resistant to that. You don't want to think that this has all been for nothing. This has all been for nothing, and now you're just back at square one. And now it's 7 years later instead of 5. The case is that much colder. It's devastating for them. Of course, they don't want to think that. I get it. I get it. JD, didn't they hand a subpoena to the doctor today after she got off the stand? Grateful for your passion and conviction. If they did that, I didn't see it. If it was after she got on the stand, I thought they already had her under subpoena, but I could be wrong. They may have just named her as a witness and not actually had her under a subpoena. I don't know if there's really anything they need to bring her back for, because at least they didn't try anything that was really beyond the scope. But yeah, no, the subpoena handed to was Brad Weber. What a moment. Tay Marius, he could have been trained, scared to a forensic unit at one of 4, transferred to a forensic unit at one of 4 state hospitals, no conviction needed, and he would be properly medicated if needed. Yeah, you often do that with gravely disabled people. You don't just leave them in the same environment that they've acknowledged can be contributing to the condition. You don't just leave them there and try to just medicate him out of it. Oh my Lord. Yeah, absolutely. They could have just found that he needed to be involuntarily committed. Problem with that is that interferes with their trial process, because if he's being in the hospital and he's being forcibly medicated, they're going to have competency. They're going to raise competency issues. I mean, they have to. They really have to. He can't. They can't keep that secret is the problem. And I feel like really the way that they were able to get away with so much of the stuff is I think that they were able to keep it under wraps, like how bad it was when it was happening. Circus Music, Jay Embry believes BB lured them to her car. Yeah, I know there's a lot of theories. I want to see evidence. We've seen evidence for some. They got ruled out for reasons that I don't always really see as being very logical. Oh, you said you went to a hospital in Muncie and therefore we're done. That's not really how alibis work. Oh, you were at work, clocked in and it didn't clock out till 4:30. Well, that doesn't preclude you from being involved after the fact. A lot of theories. I've seen some good evidence that raises my suspicion for some of them, but I would definitely want to see more. Justin Maxwell, Robertson v. Walls. Is that Walla? Robertson? I'll write that down. Robertson. Okay, I changed my note. Thank you for that. I do want to check that out. Kim R., the more cases I watch, the more grateful I am for the amazing LE and prosecutors I had the privilege to work with for over 25 years. Thank you for bringing this case to light. Yeah, the good ones, you really do appreciate them so much more when you have this kind of comparison, when you see how bad it is, and that this is tolerable. This is tolerable. Nobody's done anything about this. Nobody's lost their job. Yeah. You see how bad it is. You really, really do appreciate the good ones when you see them. And there are, I just got to keep saying, there are lots of good ones. There are lots of good ones. Prosecutors play an extremely important role in the system. Of course they do. You need a prosecutor to go out and get justice for Abby and Libby. If the police could actually, build a case. Police built a case. You need a good prosecutor who can charge it and who can be tough and who can, represent the community and the vindication that the community needs when something like this happens. And just, defend the dignity of this victim. We do need good prosecutors. So they are out there. Ladybug Lisa, case may meet probable cause, but this is trial. I know. And that's the thing. Like, with what we've seen at trial now, we're realizing that even the original probable cause, yeah, it wasn't all that. No, a lot of the stuff in the probable cause, they had to skew it. They had to put their finger on the scale. They had to make it misleading. They had to put words in his mouth. They had to distort the description of the bridge video and like what exactly is shown on the bridge video. I went back and got that part of the probable cause affidavit because somebody was asking like, how much of this could you actually see on the video? So I went in and highlighted the parts that like, there's no evidence for this claim on the video. Him putting himself in the clothing that the bridge guy wore, like all that stuff. It's just, as we've gotten into trial, the weaker and weaker it is. Tay Marius, typo transferred. One more, Shauna King, Robertson versus Walla, not Robinson, typo. Thank you. I got that. I fixed it. So thank you very much. Starlight Selenite, it would be great if you wrote a book, Andrea. I will think about it. I will. It's crossed my mind before. I definitely have, all the notebooks I could ever need. And just the whole experience, I would want to think about how to tell the story of this trial, because I certainly want to be sensitive to the families. But there's just so much to it. There's so much to it. I would hate to, I don't know. I would just hate to do something that would cause more pain, to them. But, I think there's ways I could theorize. I could figure out how to do that. So it'll be on my mind. I won't rule it out. I'll give you that. Linda M., thank you. Guy on death row in Texas, 100% innocent. Robert R., he got last minute stay. It will blow you away. Juror just testified. It must get attention. Is this the shaken baby? Is this a shaken baby case? The one where the prosecutor, a good prosecutor, came out and said, actually, I have doubts about this now. I don't think you should kill this guy. Please support prosecutors like this, ones that are willing to say, I made a mistake, I got it wrong, and are willing to step up and try to do something to make it right. These are the good prosecutors. These are the good prosecutors. Find them and support them. Robert R. Death Row, Texas. Got all my little notes here. Tater Tot, do you think speaking out, they may try to keep, if you mean like try to keep me out, that would be a problem. That would be handing me a 1983 action if I could show that they are, discriminating against me because I am exercising my First Amendment right to criticize this process and to criticize the participants, which is a form of public speech when you're talking about government officials, court processes. Highest, most protected form of speech in the United States. That's what we do when we talk about court cases. We are engaging in political speech. So it would be a pretty stupid move on their part. I'm not really expecting that. Michelle Damadeo, between you, Lawyer Lee, and Melanie Little, I've learned so much. I've lost faith in Indiana law. There is so much left on the table because they decided RA did it. Sad. Thanks for your hard work. I don't know how much of this is Indiana law and how much of this is just the people that are in charge of implementing it. I didn't get the chance to get as familiar with Indiana law as I would have liked, because normally what I would be doing in a situation like this, like while I'm watching a live stream or something like that, I have my device with me. I get to sit and research the law as we're watching the case and as issues come up. And I can see specifically, oh, this is how Indiana does it. No, that's real interesting. Here's how it compares to other places. Really haven't had the opportunity to do that here. So I haven't been able to really get familiar with Indiana law, and I don't want to condemn it. I've noticed like some kind of strange things about it. Don't get me wrong. The whole like jury getting to talk about the evidence before they go into deliberations, that blows my mind. That's weird. But so I don't want to blame the law. I don't want to blame the system. I think it's very likely human error, in the sense that it's people that have the power and the opportunity to be able to exercise it. They're the ones that are causing the problems. The law is just the tool that they use. J. Margaret, it's sad most people in the U.S. don't care unless it affects their life priorities. Until good becomes majority, money and selfishness will dictate heavily. Some of that is just always inevitable. It's natural. It is. It's natural for anybody to care more about their own child than a child halfway across the world. It's just normal. So I definitely don't condemn people for, having their focus on the things that are closer to them, because we can't look at everything. We can't. I would love to. I love to learn. I love information. I love stuff like that. I would love to be able to know, although I guess if I knew everything, then I would get bored. I would love to learn, as much as I possibly can. But, everybody has to pick their priorities. But I do think it is very important to think beyond yourself and your own narrow interests when you're thinking about the things that are important to you. So I care about court cases. Not everybody cares about court cases, and that's okay. Not everybody has to care about court cases. And some people that will come to the channel are coming to the channel because they have their own court case, and that's what they are most interested in. And they want to see if there is, something they can get from my channel that will help them with their personal interest. And they don't really, they don't really care about the broader stuff. I can't really judge people for what they care for and what they don't care about. I just really ask, don't harm. Don't harm. Don't do harm. If we didn't have these people that were out here creating problems, with the system, then it wouldn't matter that people, don't care about it. It wouldn't matter. It's always the wrongdoer's fault. It's not the fault of the people that just don't have the ability to pay attention to it. But yes, everybody could stand to be less selfish. I will certainly agree with that. I mean, nobody's perfect. Nobody's perfect. We can all be better. True crime addicted. Have you gotten any sense at all that Abby's or Libby's families are questioning RA's guilt as they hear all of this? Really, the only, I mean, like I said, the only like signal kind of thing I've gotten was just that yesterday everybody was really somber. Everybody was really somber. And it's hard to know how much of that is just the emotion of the day, but it just seems like, if you really think this guy is guilty, are you going to be that bothered by it? I don't know, maybe. Maybe. I mean, if you're a good, decent person, yes, you care about people being mistreated. It's just that if this person, brutally murdered your loved ones, really going to be hard to gin up sympathy for them. So I did see that as like a maybe, maybe there's maybe there's a realization here. Maybe they are realizing that this man does deserve some sympathy, and that, if they're willing to consider that he deserves some sympathy, then, sort of by definition, maybe he's not the guy that killed their loved ones. But I don't like to try to mind read, and I don't want to, I don't want to project. I don't know what they're thinking. I really don't. I really don't. Simone, also Johnson v. Walla, and you've got a citation and everything. Writing it down. Johnson v. Walla, 323, a nice pacer case, easy to find. 1017 HAB SLC, June 18, 2024. Well, gosh, with all these lawsuits against her, I'm wondering why there wasn't a lawyer there today. I mean, I can understand all the DOC lawyers, man. Where was hers? Yikes. Guys, I'm checking out. Appreciate it. Appreciate all of your support. Really enjoyed getting through the end of day 14. Looking forward to being at the end of the state's case here and getting to see what the defense has got. Very much looking forward to that. We are getting close to the end of this, and I'm feeling better about it. It's had its very hard moments, but I feel better about the trend that we're on at this point. So yeah, it's going to be good. I am going to check out so that I can finish the last little touches I need to do to get ready to file this writ. Fingers crossed tomorrow or the next day. Like I said, it's got to go through this pre-screening thing, but that's going to be my priority. Then I'm going to get some sleep. This should be hopefully my last night on kind of short sleep for a little bit. And yeah, we'll get into the defense case. I've been waiting. I've been waiting. I'm so waiting that like I'm having a hard time waiting. Like I'm so eager for it. I've just been dying to hear what they got. So I'm really looking forward to it. And we got a great preview. Great preview of surprises. They have surprises for us. I was very surprised today. I enjoy a good surprise at trial. So we'll see what they got. Appreciate all of you. Appreciate your concern for this case. Appreciate your concern for justice. I appreciate your desire for justice for Abby and Libby and your scrutiny of this case so that we can all see together if that's what we're going to get here. Because that's the ultimate measure of our justice system. Is it providing justice? And so if it's not providing justice to two brutally murdered young girls, then that's something that everybody needs to know, particularly those who are in this community and have to live under the system that can't provide them justice, that won't provide them justice. And that, makes up for that inability by just perpetrating more injustice. Everybody needs to know that. Thank you all so much. Really appreciate it. I look forward to seeing you guys tomorrow. We'll get through day 15. I'll be here on the live stream, same time, 7 o'clock. Looking forward to seeing you all there. Have a great night.